a major landmark change in the coming time. Indian Staffing Federation as a body is representative of the contract staffing industry, and we are currently representing close to about 1.1 million temp workers to our 100 plus members. May I request our president, Mr. Lohit Bhatia, to kindly address the group that we have from everyone, starting from us, well-versed speakers on the subject, as well as the attendees that we are close to about 200 right now.
Thank you, Suchita, and good afternoon, everyone, from wherever you're joining. I'm speaking from Delhi NCR. It's not a foggy afternoon, but it's a smoky afternoon. For those who are in North and in Delhi NCR, understand what happens between Dussehra and Diwali. So while the country tries to solve, the environmental crisis, we are today here talking about another thing which probably from a labor standpoint was the need of the hour for a very, very long time. A lot of people have asked ISF and myself in particular in the last couple of days as to what we feel about these changes and the 4 labor codes. In short, I've often gone back to tell people what happened for all of us on the call today. All of the knowledge workers, the white collar workers, the IT workers in 1991 when the economy really opened up and the services sector did so well, the options that all of us got in our professional careers, the kind of growth that the services enterprise and services industry saw in India, the labor codes announced in 2020 in the next decade or two could possibly do the same for our blue collar, our frontline, our gray collar workers. And if we get this right in the next 10 to 20 years, I think India would not just be a great knowledge and a services economy, but it can become a massive manufacturing economy, a strong MSME economy, and a very, very strong, resilient economy in itself. So whether the government intends to next go to a $5 trillion economy mark or a $10 trillion economy mark, this was definitely long overdue. And thanks that finally the government has probably been able to get this passed in Parliament. The President has already assented. Today we have a great panel on behalf of ISF, starting with none other than Mr. Vardhan from Aprajita Group, Madhu Damodaran from the Quest Corp Group, Unni Krishnan from Randstad. We have Sushil joining us from GI Staffing. We have Suhas, who's the Managing Director of Prompt Personnel. All of them will talk to us about the 4 labor codes. What has primarily been announced with these 4 labor codes? What has possibly been the change as far as these labor codes and its impact in the economy and in the sector of staffing and the non-staffing employment industry is concerned? They will also take question and answers from all the participants that we have today, and we would like to keep it as interactive as possible. And before I pause, I must thank Staffing Go, our sponsors for today. They've been participating in the journey with ISF for a fairly long time. 100 of our members employing close to 1.1 million frontline workforce would not be possible to achieve some of the things that ISF has achieved unless we had partners and we had sponsors like Staffing Go supporting us from time to time. So thank you very much. Over to you and back to you, Suchita. Let's have a great conference. Look forward to some energizing questions, and thank you, panelists, again.
Thank you so much, Lohit. Without taking too much time, I think I would directly invite Mr. Suhas Vasaketre, MD from Personnel. He is going to be discussing on the Code of Industrial Relations 2020. How we have designed the session is the speakers will be taking up each of these sessions, each of these codes, and discuss it individually. And post that, we will be taking in the questions with respect to individual speakers or to the codes that we would like to have the speakers and the attendees address. In the meanwhile, everybody who would like to put in the questions, please feel free to use the Q&A section for putting up the questions. We will try and address as many as possible in the session today. Mr. Suhas, if I may invite you to kindly take up the session from here on.
Thank you, Sujita. Good afternoon, everyone. I'm really delighted and very much happy and pleasure to be here to present Industrial Relations Code. I must also thank the ISF for giving me this opportunity to present and speak in this webinar. So before I move to the details of the Industrial Relations Code, where you have seen that Industrial Disputes Act, Industrial Employment Standing Orders Act, and Trade Union Act have been amalgamated. So before I give you more details about it, one must understand the background of why they had to do it. And I fully agree with Mr. Lohit when he said about this is going to be definitely a game changer for Indian economy. If you have noticed, these acts are pretty old. Some of the acts, two acts are almost 74 years old, and one act is almost 96, 94 years old. These are obsolete acts which were required to be rationalized much earlier. And if some of you are fully aware, the Industrial Relations Bill was also formulated about 20, 25 years ago. But because of lack of political will on the part of ruling government, it could not see the light of the day, and therefore the rationalization, could not happen. But why was it required? If the industry has to survive, the industry must have some free and a very, very convenient and simple process to, regulate the working conditions and the employment scenarios. If industry has to survive, okay, the employees, the unrest, the industrial peace also has to be maintained. And this is precisely has happened here, that in order to keep the industrial peace in mind, in order to see that how industrial unrest can be avoided, keeping these objectives in mind, the rationalization has taken place and this amalgamation has happened, and how it is going to help both the parties, the workers, the employees, as well as the employers, is going to be seen in this Industrial Relations Code. It's a very vast code which has close to 100 sections and about 14 chapters with 3 schedules. To talk about it, one can take almost half a day or something like that. But with the challenge of time, I'd like to see what best I can cover the important elements of this IR code. So let's move to the applicability of this code. This code applies to all establishments, with separate threshold limit, with retrenchment and closure, and for requirement of standing orders, etc. The chapters relating to trade union and industrial disputes, okay, applicable to all establishments and workers. The chapters relating to standing orders applies to establishment with 300 or more workers. It's very peculiar in a situation. And all chapters, except chapter 3, which is relating to trade union, applicable to all workers, including workers in supervisory capacity, earning wages up to INR 18,000, which was earlier about 10,000. Let's look at some of the definitions. The wages definition is common across all the 3 codes, but one of our colleagues is going to talk about it in detail in his separate presentation. The contract labor definition has also been revised to include interstate migrant worker and part-time worker, and it has excluded direct employee of contractor who is engaged on permanent basis. This is very, very peculiar. This has happened. If you have seen the Migrant Workers Act is there, but still the protection of their interest is still not achieved to the great extent. With this code, perhaps the government may achieve it. The worker definition, it includes working journalists as defined in the Working Journalist Act, and sales promotion employees also as defined under Sales Promotion Act. It is unclear whether these 2 acts are repealed or not. Mostly they would be. But it has excluded semi-skilled workers. It could be a mistake, I do not know, because the Minimum Wage Act has unskilled, semi-skilled, and highly skilled and all. But here the semi-skilled part is missing, which I guess eventually will be rectified. Apprentices registered under the Apprentices Act 1961 are excluded, whereas earlier definition of workman under ID Act it was included. There must have been some thought process. Let's look at it differently. Now, new definitions have been introduced, which are very interestingly, to be looked upon. See, earlier there was no mention of fixed-term employment as such in any of the acts. However, many judgments have a reference of FTEs in their ruling and allowed this term keeping in mind the tenure of the projects as against the permanent nature of work. However, industries have been using this FTE for regular nature of work also. And I'm sure many of you will agree, most of you would have FTEs. But court view towards it as a sham and bogus. They don't recognize it to that extent. Therefore, there have been some industrial disputes as well. Therefore, government have thought through this in favor of fixed term employees, and therefore the gratuity provision has been included to see if they are not deprived of. At the same time, if you have seen the all benefits, social security benefits at par with permanent workers are also to be provided to FTEs. Even termination of completion of tenure of FTA now will not amount to any retrenchment. The industry now has certain specific exclusion. This wasn't there earlier. The charitable institutions, social organizations, philanthropic services, even domestic services, and certain central and state government activities are excluded in industry. This industrial dispute can happen anywhere, employee, employer. It used to be, in these kind of specific industries also, which used to come up, and there used to be a lot of havoc. So they have been spared to carry out their, social objectives, serving to the society. Earlier definition of industry was very limited. It was not so specific. Now the strike provision also is something very interestingly, the definition is tweaked. Employees going on mass leave, and if the overall strength is over 50%, I think it would be considered as a strike. And of course, it will be termed as illegal strike, and they will be not paid the wages for those number of days, 1 or 2 days. Okay, this used to be strike used to be the tool for very unionized employees, and they used to. It is being used also nowadays to give threat to the employer and something like that. There are some procedural requirements I'll talk about. They have streamlined the structure of resolution of industrial dispute. It has removed multiple adjudicating bodies. Now the code provides resolution of disputes through a conciliation officer or industrial tribunal and national industrial tribunal. What does it mean? In earlier case, if any dispute arises, it is to be referred to the labor department, either the assistant commissioner or the deputy commissioner, depending on the gravity and the quantum of the case. I used to deal with the case, and the conciliation officer used to give his report. It could be failure report of settlement. If at all the amicable settlement never arrived, he used to straightway send it to the government. The government then, in that case, used to refer it to the labor code or industrial code, as the case may be. And the cases used to go on for a long period, and that used to have a total injustice and total unrest in the industry. Because of these pending cases before the court, a lot of unrest used to happen and used to hamper the productivity. So therefore, what government has done, they have eliminated that part, and they have made 2 members in tribunal. So within 45 days, if the dispute is not resolved, it is referred to tribunal. Judicial member, the judge, as well as an administrative member, he could be anybody from the labor department or maybe from the government, can be part of this 2-member team who can give the judgment. No wonder today there are so many cases pending before the labor court and industrial court. I think this will give, sort of this will expedite many industrial disputes to resolve. Strikes and lockouts, some procedure requirements. Notice period for strike and lockout is now given 60 days. So within 60 days, the members cannot go on strike. And in earlier case, 14 days of notice was required, applicable to all establishments. An employer is also today now in this industrial relations code required to report the authority within 5 days of receiving strike notice. So the intervention of the departments and the government is also invited. The retrenchment layoff closure procedures. Establishments with 300 or more workers to take prior approval of central or state government before layoff and retrenchment, as opposed to earlier threshold of 100 workers. It used to be so difficult that today the size of establishment is different. The nature of establishments are different. So there has to be liberty. With the view, the government has increased this threshold to 300 workers. So the establishment need not go to the department to lay off and retrench people. If they have valid reasons to do so, they may do so by following the due process of law. And again, mind you, there are very severe offenses and severe penalties in case these layoff and retrenchments are found to be illegal or not fair. That I'll just cover in my next slides. And the retrenched workers also will have to have a first right to refuse within 1 year of retrenchment if the re-employment opportunity is not created. And you are aware that in earlier case, in today's, I would say, the employee is required to be offered alternate employment within the radius of 5 kilometers or alternate the first job immediately if the requirement or the vacancies arises. That is now is limited to 1 year. And this has, related to reskilling fund, how it is going to be useful for the workers and the community is something that we must take into account. The introduction of workers reskilling fund is the new thing that has been introduced in this higher code. In case of retrenched worker, the employer is required to contribute equivalent to 15 days last drawn wages within 45 days of retrenchment. Ladies and gentlemen, this could be because the government wants the opportunity to be given to the retrenched worker to upskill himself in any of the skill or the area which he wishes to. And it is unclear today, but it is said that perhaps this could be linked with the the retrenched worker could be referred to National Skill Development Corporation partner, or maybe ITI, or could be like that. And the fund which is deposited would be utilized to train the person and make him employable again. And the disputes relating to termination of individual worker, I think within 45 days, if it does not get, the conciliation officer does not give any relief, he may move to tribunal. Now let's move to the standing orders. Within 6 months of this code becoming applicable to the establishment, they must apply for the certification. And there is a process of certification, the preparation and submission of certified standing orders. Okay, and it is listed in the Schedule 1 to whom it is applied, 300 and more workers. This draft is required to be referred to the negotiating union, and which is the negotiating union, I'll be talking about it in my next slide. If the model standing orders are adopted in totality, then it is required to be intimated to the authority and shall be deemed to be certified. Where there is no union, the representatives that workers choose may be heard by the certifying officer. It is unique that for the first time where establishment having 300 workers now compulsorily have to have some negotiating body of workers, which not mandatory before, and how it will be covered in the trade union chapter, which I will mention. Wherever there are existing orders in operations will be deemed to be certified under the code. The existing certified orders shall be valid. Now, FTs are also included in the certification, which wasn't there earlier. And no power is given to the central government to make provisions related to standing orders applicable to establishment with less than 300. I mean, they feel that this need not be, the threshold should not be reduced. And there is a little ambiguity on impact of reduction in the number of workers below the threshold of 300 workers. One never know what can happen today if it is certified, if it is applicable. If the headcount drops to 250 or maybe 200, what will be the situation? Nobody knows. Let's talk about the trade unions. Here is the catch: the introduction of negotiating council or sole negotiating union to become a single point of contact for the employer. Where there are two or more trade unions, the employer is required to designate one union with 51% or more support as sole negotiating union. What does it mean? It means the union will have to have the support and the membership of more than 51% of the employees on the muster roll of that company. And if there are two or more trade unions with less than 51% support, they will have to designate one representative for each 20% of support that they receive. What does it mean? What happens thereafter? Wherever there is one trade union, they will have to designate it as a sole negotiating union. But if there are more than two or three unions, then what happens? So for every 20% of the block, one representative will be designated, and maximum up to 5 members, this negotiating council will be formed. And this negotiating council is entrusted with the responsibility to address various issues related to employment, related to working conditions, related to certifying orders. And amongst them, they may decide the leader of the group or leader of the council. So I repeat, negotiating council where there is no majority of the union, and sole negotiating union is the one which has the maximum, that is up to 51% and more membership. Ladies and gentlemen, some of you who are aware, in Maharashtra, there is an act called Maharashtra Recognition of Trade Union and Prevention of Unfair Labor Practices, which has this provision of 30% of the membership to get the recognition in the code of law. And there's always a fight between two unions having more than 30% membership. This particular aspect has been taken care of, and in order to create the peace and the harmony and to remove the ambiguity, they have made the provision of 51% membership, 51% or more membership. And these are some registrations and returns which I'll skip. There's a limitation period, conciliation officer and tribunal. The code provides for a limitation. The adjudication process is very simplified. As I mentioned earlier, it eliminates a lot of time that used to get consumed in the past. The period of 2 years of institutional proceeding means if any worker registers dispute, after 2 years of his termination will no longer be hold good. So he has to apply before the 2 years of the period. There are severe penalties, as I mentioned earlier, and offenses. The first time offenser of retrenchment and layoff, which I mentioned earlier, to fine up to 10 lakhs, it has gone 10 folds. The subsequent offense, the imprisonment up to 6 months and fine up to 20 lakhs to the employer. I mean, these are very restrictive provisions they made for layoff and retrenchment. And again, for the workers, illegal strike, imprisonment up to 1 month, or fine up to 10,000 rupees, or maybe both. An illegal lockout for the employer, imprisonment up to 1 month, or fine up to 1 lakh rupees, or maybe both. And for any general offense, fine up to 1 lakh. I think if you have seen here, the penalties have been exponentially, exponentially revised to make them very restrictive. Various steps that employer and employees could take. There are compounding offenses. I just skip that. And the powers of government officer, the appointment of officer not below the rank of under secretary for holding an inquiry in any matter. He could be the commissioner of labor. He could be any person from the labor department, from the government. So government has kept this option open of deciding which officer can take the decision or investigate into the matters related to industrial relations or disputes or maybe any strike lockout of a big organization. Such office will have powers to issue summons. They will be very much empowered to call for any party with short notice as prescribed in the law. And as you're aware, today uh, the law has been passed. Uh, it is ready. It is published in the government gazette, official gazette. The rules are yet to be made. They are under preparation. So it's very difficult at which state what kind of rules will be framed in terms of process, in terms of redressal. It is still yet to come out. Once that comes out, a lot more clarity will be there for all of us. So before I conclude, as I mentioned here, there are two important acts. There is a confusion because of that. One is the MRTU PAL, Maharashtra Recognition of Trade Union and Prevention of Unfair Labor Practices, and Bombay Industrial Relations Act, and similar, which is applicable in Madhya Pradesh Industrial Relations Act. These two acts had a lot of provision of giving room, or rather, for I would say provisions for the unions to get recognition, to prove unfair labor practices, and to seek relief. So they had Industrial Disputes Act as well as MRTU PAL. And for the companies which are falling under the central government, like banks, airlines, trust, port trust, or docks, were governed by this BIR Act and similar. The unfair labor practices are listed in schedule of this code, and most of the provisions of these two acts are already covered in IR. One never know why they are not repealed these acts. Maybe in the coming days they would think of removing these two and declaring it. Ladies and gentlemen, with this I conclude with the whatever short and possible time I had to cover very few and very important provisions of the Industrial Relations Code. I hope that this was a bit informative and educative, and I'll be open to questions in the end. Thank you very much. Thank you, Suchita.
Thank you so much, Suhas. I think thank you for also ensuring that we have enough food for thought for and the questions that have already started to come in. We would ensure that those questions are taken up either directly from here or at the end when we do the Q&A section. The topic obviously leaves a lot of things that are yet to be formulated in details, but I think we've got a very good picture from the highlights that you have shared with us. Moving on to the next code that we are to discuss, and thank you for maintaining the time limit also. May I request Mr. Unnikrishnan, Head of Compliance and Fieldwork from Randstad India, to discuss the highlights on the code of OSH 2020, which is also very interesting from the fact that it also encompasses a lot of laws from the contract labor and the migrant labor, which will be impacting the staffing industry for sure. Over to you, Nick. You're on mute.
Can you hear me?
Yeah, we can hear you now.
Sure. Yeah, thank you so much. I thank ISF for giving this opportunity to be part of this learning session on the decoding of the labor codes that's come out now. Uh, this is indeed a very great pleasure for me to be part with these eminent speakers in understanding these labor codes. I would try my best to ensure that, okay, I help you understand the code. So as Suhas already had explained, this is one of the very much required need of the hour. Labor reforms are very much required. Through this labor code, there is an amalgamation that's happened on the code on wages. The existing legislations around 29 labor law legislations have been central laws have been now subsumed to form into these 4 labor codes. One which is the code on wages, code on the occupational safety, health and working conditions, code on industrial relations, and code on social security. So as you all are aware, we have the presidential assent, which is coming. Code of wages has already got its assent and awaiting an effectiveness. Now even the other codes also have got the assent, and we are awaiting an effectiveness, which as of now we are not sure, but the government is working very clearly and fast to have this implemented. So what does this changes actually mean? So what is the legislative intent of these amalgamations? So basically, if you see the labor codes, you'll see that basically there is a removal of a multiplicity of definitions that's there across so many labor legislations that's already there. So if you see 29 central laws, and now the multiplicity of definitions has clearly come down. You will also see that there is a usage of technology that's been clearly brought in, which was not the case before, because we were actually reaching out to the labor offices for filings and other things, which is clearly being reduced now. You have an ease of compliance that has come in because the number of filings or forms returns have come down. There is a clear transparency and accountability that's brought in. This is mainly because there is a requirement of ease of doing business, which I guess is the real motto of the government. So there is also a racialization of the penalties that's come out. So taking into consideration all these things, the labor reforms that's brought in by the government, actually, yes, there are so much of changes that's coming in anyway. We'll surely have to wait for the rules to come out. But from a code perspective, yes, the amount of time that we may have to spend on compliance would be high, but it is seriously going to be limited with the ease of business that's come out. I'll now go to the code as such. Basically, if you see the occupational safety, the code actually subsumes around 13 labor legislations, of which the major part is the Factories Act, the contract labor legislations, the interstate migrant legislations, the BOCW, and the sales promotion, which I would see as a major part of the 13 legal legislations that have been subsumed now. So what I'm trying and do through this presentation is that the first part, I'll just try and see how can we explain the definitions? What are the critical modifications that's come into the definitions? If you see the first part to it, the first one is the employer definition, which has actually got an expansion now. It actually includes the contractor and the legal representative of a deceased employee. The other part to it of the employer definition is very much similar to what is there in the Factories Act now, where you have the occupier, you have the ultimate control, ownership of an establishment, everyone are covered. But along with that, you also see that there is an expansion to have the contractor and the legal representative of a deceased employee brought into picture. What does it actually mean? Actually, you may have to understand that there is a broadened definition now. See, the employer definition will have to be now evaluated in such a way that, because there are so much of duties that has been placed on to each of the employers. So you'll have to understand what are their duties, responsibilities. We may have to wait for the rules, but as such, yes, there is a clear change, expansion that has come out in the employer definition. When you go to the next part, which is the worker definition, you see that working journalists and sales promotion employees have been specifically brought into the scope of definition. This was not there because this was actually a part of 2 different legislations before, but now this is part of the workers definition. But you can seriously understand that there are exclusions. Exclusions similar to the supervisory power. if an employee in the supervisory level, if he's having a salary of 18,000 or more, then he's clearly excluded. Even an administrative or a managerial person is excluded in the workers definition. Now, when you take the core activity definition, which is one of the major parts that's come out in this code, which was something which was not there in the earlier legislations. In the CLRA Act or the CLARA, we didn't have the Contract Labor Act. We didn't have a clear bifurcation of the core activity definition. This was something which was actually brought in through an amendment which you would have seen in 2011 by the Andhra Pradesh government, where a core activity was clearly defined. And now any activity for which an establishment is set up, including the activity which is essential or necessary to such activity. So anything which is core, which is part of your memorandum, will become a core activity of an establishment. But sure, as such, what we have earlier ways, you still have the appropriate government having the empowerment to see if that is a core activity or not. So you still can reach out to the government in case you feel that whatever business that you're doing, where a contractor is being engaged, if it is not falling under the core activity or not, we can surely explain and understand. There is no problem. The other major thing that you see in the definition, which is very critical, is that in the occupier definition, you see that the independent director, who is as part of the Companies Act, has been removed. He's excluded. You also see that the contract labor definition has been expanded. It now has interstate migrants, which is brought into the ambit clearly, but it actually excludes if those employees who are employed for the primary business, or if it is who is regularly employed by the establishment of a contractor, he is clearly excluded from the definition of a contract labor. So that clearly means that your core employees of a deputation company or a staffing company will not fall under the definition of a contract labor. So that clarity has been brought in, but you have an expansion now. The interstate migrant, which was clearly a different legislation, has been brought under the definition of contract labor. The other far most important thing is that the contractor definition, which was a twofold, which was one before, which has a sub proviso now, which is supply contract labor for any work of establishment as a mere human resource. What does this mean? So even a deputation service, now even the outsourcing service, which was a long-standing demand of the industry bodies, has now been brought into the contractor definition. So even a mere human resource supply will be considered as a contractor now. So it would be coming under the definition of a contractor now. The other clarity that's brought in is the appropriate government. So wherever anything is controlled by the central government, it is surely the central government's purview. But if the factory is set up in a state, the state government will be construed as the appropriate government. Now I'll move on to the next part, which is the manufacturing process. That also has an expansion, which also has some new definitions which has been brought in, which is offset, screen printing, 3 dimensions, etc. So it's very clear that the government is trying to expand the items that can be considered as a manufacturing process, with the government given the flexibility to even notify additional processes also. So this is a very clear indication that, okay, the government would come up with certain notifications in the rules and other things. The other important definition, which is very critical, is the BOCW definition. Earlier, we didn't have a clarity as to whether a building or any other construction works that were happening in the factories, whether it will be coming under BOCW or not. But now that clarity is very much there, because there is a clear exclusion that has come out in the Act, which tells that building and other works related to any factories is excluded. You also have an exclusion with respect to residential construction things, which is not exceeding 50 lakhs. So these were some things which had a clarity issue before, because those constructions which are coming out in the factories, we were not in a position to understand if it's a greenfield or a brownfield activity that was happening. So there was always a difficulty in understanding the requirement of the compliance under a BOCW, which is now clearly excluded in the Act. So this is a welcoming move. Now I'll just run you through with the key synopsis that's there as part of the code which has come out, basically on the applicability and the registration part. So if you see, the code is now applicable to every establishment. Before it was not that way. Now the ambit of this code is very clear. It's expanded. It is expanded in such a way that even a commercial establishment, including IT and IT-enabled service establishments, are getting covered under this code of occupational safety. So you will have to understand that now there will be compliance requirements that would come up when you employ more than 10 or more workers in your establishment. It was not the case before. You always have a timeline from the applicability of this code to have these registrations done. So it's 60 days within the time this code gets effective. That is when you will have to do an electronic filing to get yourself registered under the OSH code. And the central law legislations are no longer required. You don't have to do a direct application. It's an electronic filing that's come up. There are certain other pointers that are also come up as part of this OHS code, whereas if there is a change in your management, if it's in the composition of the board or anything that's come out, you will have to do a filing. That too, within 30 days, you will have to do a filings with the appropriate government to intimate them about a change in your composition. This could be a board of director change that's happening because of an acquisition or whatever be the case. You will have to now intimate about these compositional changes within your organization. The other point is that even in case of a closure, you will have to file an application within 30 days. And the most important part to this is that you will have to file an undertaking or a certification telling that all your workers' dues are paid. So this is very, very important because you cannot go for a closure now, even for a Companies Act closure now, without having these certifications done if you are coming under the purview of the OSH code. So you will have to do a declaration telling that your wages that are due to the workers are completely done. And this needs to be done within 30 days. The other important change that you could see is on the working hours and leaves that's come out. Now, the earlier Factories Act had a 9-hour work schedule that was being brought in, which is now being changed under the new act. The OSH code brings in an 8-hour per day work schedule and a 6 days per week consideration that's been brought in, the working hour part. Overtime is still possible, but the most important point that you'll have to consider now is that a prior written consent of the workers is required for you to do an overtime. And during overtime, you will have to pay double the wages. So that is something which you will have to take into consideration when you are framing your compliance requirements, because without the prior written consent, if an employee is being asked to do an overtime, this would surely violate the OHS code regulations. The other important thing which was not there in the Factories Act or the Mines Act was women employees work schedule, which is now possible. A 7 p.m. to 6 a.m. work schedule is now possible, that too with the consent. The most important part that you'll have to consider is that the safety of the women, the health and safety and other compliance requirements that you need to follow has to be done when you allow your women workers to work during these time schedules. And this is with a consent. Now, let me go to the leave with wages. So earlier Factories Act, the calendar year, the number of days was considered as 240, which now has been changed to 180 days or more for the calculation of leave with wages. And the act or the code specifies that 1 day of leave for 20 days of work is per year has to be provided to the worker. Now, what does this mean? Actually, the quantum of 240 has actually been reduced to 180 days. A carry forward possibility is still retained. You don't have a problem. The worker still can avail the encash the unavailed leave balance at the end of the year. That is still possible under this act. It doesn't have a problem. But when it comes to 180 days with this changeover, actually speaking, the employees are now being able to get more leaves. That is, they are able to get the wage annual leaves with wages more sooner than what was there before in the Factories Act, where it was 240 days. Now it's reduced to 180 days. The next part that I would like you to understand is on the revised definition of the contract labor applicability. So on the bill that was there, the threshold limit was placed at 20. which is now increased to 50 workmen in the preceding 12 months for applicability of a contract labor to come into picture. One of the major things that's come out is the 5-year validity of the license that's been brought in. So this is subject to those manpower consulting agencies or any other contractors. If they have to get a license, there are certain prescribed qualification that needs to be complied with. We may have to wait for the rules to understand what are these qualifications. As of today, it's not there, but there would be a minimum qualification that's required for you to be eligible to get a 5-year license validity. So the 5-year license actually helps the contractor because you don't have to do a regular yearly renewal of the licenses, which is what we do currently, which is a very cumbersome process, which is actually reduced. So if you don't have a change in the number of employees, then you can still have a validity for 5 years. And for those contractors who doesn't comply with the qualification requirement, you still have a work-specific license, which is possible. So this is a very engaging thing that's come out in the code. The other point that we may have to look into is that the government is very keen on ensuring that the payments are done electronically. So cash payments have to be avoided. You'll have to have a proper process where you electronically pay the wages to the contract labor. And certain conditions which were there in the CLRA Act is still continuing, wherein if there is a failure in payment of the wages by the contractor, the principal employer can still make the payment and have this, as per the contract, taken back from the contractor. But the most important thing that has come out by this code is that now you have the government also coming up. If there is a failure in the payment of wages, the government has the complete ability to ensure that, okay, they utilize the security deposit that you have placed as part of the licensing process. So you will have to be very clear in ensuring that, okay, you don't have a miss on your payments to the contract labor, because this is actually going to have an impact on the security deposit. And we may have to see how the rules gets framed to see if there is any other exceptions or conditions that would be placed. But as of today, the code seems to say that, yes, if you have a failure in payment of wages, then surely there is a delay, there is a deduction that's going to happen from your security deposit to have these payments made to the contract labor. Now, the other concept that has come in is on the core activity, which was actually something which was not clearly defined in this Contract Labor Act, because you only had the appropriate government taking a decision whether they have to prohibit a particular activity if it falls under the core activity under Section 10 of the current legislation. But this has got changed now. Now the emphasis is more on the emphasis is given. It is more of a self-analysis that's been brought in. You will have to ensure you have the definition clearly defining as to what a core activity is, and there are certain exceptions. So if it is well within the normal functioning of an establishment, you don't have a problem in having contract laborers placed in your what you call in your core activities. You don't have a problem if there is a if they are not part of your full-time, the full-time workers are not engaged in the core activity. Surely you can still employ contract labor. And if there is any sudden increase in the work pressure, surely yes, in the work volume, you can surely have the contract laborers placed. So this possibility is still there, but now the definition is very clear with certain pointers that's been placed as to what are the exceptions, what are the items that doesn't fall under the core activity, like sanitization, if it is housekeeping, or any other activities like ambulance service. So there is a number of items that's been placed under the code with OSH code, which clearly tells us, okay, what are the exceptions under the core activity. Now, the other thing that we'll have to understand is that the interstate migrant workers have been clearly explained now. So every establishment who is employing more than 10 10 or more interstate migrant workers, the interstate migrant regulations will be applicable. Before it was the interstate migrant was more from the contract labor perspective, this compliance was required, but now even those employees who are employed by the employer or the contractor, this becomes an important positioning. So one of the major thing is that any employee who is moving from one state to another the compliance under the interstate migrant worker will be coming into picture. It will be also for those cases where an employer takes an interstate migrant. In those cases also, uh, from another state, you will have to comply with the regulations of the interstate migrant worker. The exclusions that you see under this is that those individuals whose monthly wages are in excess of 18,000, in those cases alone, you don't have to comply with the requirements of the interstate migrant worker. So what are the other things that you see under the interstate migrant worker is that uh, the responsibility of an interstate migrant is for them to self-certify themselves in the portal that would come up for tracking the interstate migrant, wherein they'll have to self-certify which state they are from, along with their Aadhaar card. So the Aadhaar requirements are very much mandatory nowadays for validating this position. You'll also have the facilities under the interstate migrants will also have the facilities or benefits under the ESIC and PF that would be getting covered to them. Journey allowance is also being provided to them. And in case of any fatality that is happening during their work schedule within the establishment, there is a responsibility on the employer's side that they have this intimated to both the states, from the state in which they are from and the state in which their work location is situated, along with intimating their immediate family members, is now the responsibility of the employer or the contractor, whoever is deploying these contract workers. So this is a very important thing that you will have to keep in mind when you are employing interstate migrants. So the compliance framework needs to change. The database needs to be updated to ensure that, okay, you have a proper tracking with respect to interstate migrant workers. The other important thing is on the Factories Act, the definition has been split to have 10 or 20 or more workers with the aid of with power, and 20 to 40 in case without power has been brought in. The appropriate governments still have certain requirements where they can actually exempt certain establishments from obtaining the factory's license. Now I'll move on to the other pointers, basically on the audiovisual workers and the working journalists. So now earlier, the description of the cine workers were not so exhaustive, but now you have a very clear definition on the audiovisual worker. So the entertainment industry actually has to ensure that, okay, they have to streamline their compliance mechanism, because there is a extension of the definition. Now it covers many people, and the prescribed remuneration limits, we'll have to see how the thresholds will be kept by the central government. Similarly, working journalists and the sales promotion employees, if you take sales promotion employees, it was more for those notified pharmaceutical sectors and all. But now with this code, it is now applicable for any establishments where sales promotion employees are placed. So you will have to reframe your compliance mechanisms to understand that, okay, you ensure that you comply with these requirements of these definitions and the and ascertain the applicability. Now, what are the key welfare activities? So as an employer, the major responsibilities that's brought in under this code, OSH code, is the hygienic work environment, clean drinking water, toilets, ventilations, and adequate lighting. So these are responsibilities of the employer. So there will be a financial thing, because the code now is applicable to all establishments. So considering that the code gets applicable to all establishments, you may have to reassess your existing facilities within your organization, because you'll have to have a separate shelter or rest rooms where the applicability is now reduced to 50 from 150 ordinarily employed workers. There is a canteen facility that's brought in. So you'll have to check your thresholds to see if you need to have a canteen facility within your establishment. There are also the requirements of an appointment of a welfare officer. The thresholds have been brought down from 500 to 250 or more. And you also have a requirement for an ambulance room. So these are very generic requirements that's come out in the OSH code. So you'll have to keep a clear understanding as to what welfare activities you'll have to keep within your organization, because you don't know when the code gets effective. So you have a very little span of time. So you have to reassess basis the code to see if these facilities are already there in your organizations or not. So one of the major factors that you'll have to understand is that this is applicable to all establishments. OSH codes becomes applicable when you have 10 or more workers employed, so employees employed. So the major part that you'll have to understand is that welfare initiatives is for all establishments, and you also have to create certain committees to ensure that okay, these initiatives have been properly taken care with due representations from both employer and worker. Now, what are the other important factors that's come out in this OHS code is that the emphasis is not on penalizing an employer. It is more of giving an opportunity to be heard, because you have many pointers that's come out in this OSH code wherein you have a mechanism to compound. The inspections have become automated. You don't have to reach out to the labor office. You can automatically submit basis the inspection requirements that's coming up through the online portal. And always there is an opportunity to rectify the errors that's happening. So even if you violate, or even if there is any deviations that's happening from the existing code, you still have an opportunity to rectify it. And if that is done, then you don't have to get yourself penalized, because as you would have seen in the earlier slides also, the thresholds of penalties have increased manyfold as what is there in the current Factories Act or on the Mines Act. The penalty thresholds, or in the CLRA, the thresholds are very low, but here the penalties are very huge. So the opportunity is also given to the employer to get himself rectify any of the changes that's happening or any of the deviations that's happening from the code. The other important thing is on the Social Security Fund, which is for the welfare of the unorganized sector. And this is basically from the amounts of funds that's obtained from these penalties or compounding fees that's obtained from the employer. This is more for bringing in the unorganized sector, bringing the benefits to the unorganized sector, which we will see in the Social Security Code that will be explained by the next speaker. One of the major things that you also see is that the government has now understood that, okay, there is a very clear indication that, okay, because of pandemic, there can be requirements of certain legislations that needs to be kept on hold, because there can be some compliance things which may not be possible. So now certain public emergencies have been clearly defined. So the appropriate government, which would be the state government, will have the authority to have certain regulations stopped in case of a pandemic, which is something which is very welcoming move by the government because of this COVID-19 pandemic, which you would have seen. The other thing is that there is a clear exclusions on the jurisdiction of civil code. So anything which is falling under the OSH requirements will not fall back to the civil codes. There is an exclusion on the jurisdiction on the civil code. So what are the key focus areas that, as because of the OSH codes, that you will have to be to have a proper track of? So one is that the code has brought in, you will have to bring in so much of changes to your policies and processes now, because there are so much of requirements that's there from the code. So you'll have to understand these and have these policies changed within your organization. You'll have to see the impact of the financial impact that's come in, because be it the employer definition extension or the broadening of the definition, or with respect to the facilities that get brought to the establishment. All these things needs to be rechecked to understand, okay, whether you have a financial impact or not, because certain facilities would surely involve financial cost. The other part that you'll have to do is that existing contracts that you have with your principal employer or contractors needs to be reascertained to understand what needs to be changed to align with the codes that's been enacted now. And you'll also have to now bifurcate the workers, because the definition of workers now include an interstate migrant. So you'll have to have a proper sheet available or a proper tracking mechanisms to ensure that, okay, the interstate migrant and contract laborers are properly tracked. You will have to bring in the digital approach, because the code is very clear. It's more of electronic, be it payment, be it filing of applications and everything. So you will have to reascertain how your internal systems are working to ensure that, okay, there is no deviations from the from the code, OSH code. So what are the major takeaways? One is from the OSH code, you don't have the principal employer's requirement of having a registration is anyway taken off, but there are more categories that's been brought under the contract labor definition. So there is a requirement that you'll have to look into. There is a mandatory requirement of having the appointment letters given and the experience certificates that needs to be provided to the contract labor in case of on demand. So whenever there is a demand, you will have to surely have the experience certificate provided. The formatting of these experience certificates is in line with the rules that would come out. There is also a provision for recovery of wages from the contractor's security deposit. So you'll have to see how you frame your payouts. And there is a prohibition that's brought in on the engaging of contract laborers in the core activity. So you may have to understand the core activity definition and the exceptions that's been provided under the Act, and the vast changes that's brought in the penalty terms. So this is a key understanding that I thought I would push into you to understand the code. Hope I was able to provide you a brief understanding about the OSH code. Thank you so much.
Thank you so much, Andy. That was definitely very intriguing, as obviously the presentations are going. We are getting a lot of questions. We are trying to take as many questions now, and obviously we will have a Q&A section where we will request everyone to stay connected to us so that we can ensure that we address all your questions in the Q&A section that we have post all the codes are covered. May I now request Madhu Damodaran, Head of Compliances and Corporate Legal, Head of Quest Corp, to kindly share with us the highlights, as I might just put it because the time is short, on the Code on Social Security 2020. It's a vast topic for sure, but let's try and do as much justice as we can. Madhu, over to you. Thank you so much.
Thank you. Is my screen visible?
Yes.
To ISF for the opportunity, and I think it's a great opportunity for great times from a perspective of professionals who have been like us, who've been waiting for something like this to happen. So I think finally the labor reforms are here. About whether it has taken care of all the required thing. Some people asking, is it just a cut paste job? All of that is there, but I think overall it is a welcome step. A lot of aspects of life is going to be changing from a compliance professionals who are supporting large staffing companies, as well as people on the call who are ensuring compliance for their for the principal employers. So I'll just the Social Security code by itself can take more than a few days discussion, but I'm just kind of touching upon some of the major aspects, and then probably we will take some. We might have a dedicated session on each of these codes and take it up in detail. Feel free to please post your questions. We will try to, Suchita and team, I have tried to answer quite a few while the other speakers were on presenting their subjects. So feel free to post them, and then we have some time to answer some of the key questions at the end of the session. So where it stands, like Lohit tried to reply to one of your questions on when it is going to come effective. Right, as the Labour Minister is on record saying that they want to do it by 31st December. But then the Labour Secretary has been quoted by the media saying that they are looking at 1st April of 2021. I think that's more realistic. For example, Code on Wages, which was passed last year in 2019, draft rules. First draft rules came in sometime in September last year, and then second one came in July, I think. Yeah, July this year. And I believe there are about 6,000 plus individual unique feedback, which has come from different stakeholders. The government is trying to get them all completed, I mean, incorporated or rejected with reason, and then come up with the final. The same exercise has to be gone through with all other codes as well. My interactions through ISF, etc., with the ministry and some of the officials is that they're targeting something before the end of the year from a draft rules perspective, and probably they will give some time for the industry and stakeholders to come back with their views. Anything before 1st April is unlikely. If they can achieve it by 1st April, then it is really a quick job, and all of us would have played our roles as well, because for Code on Wages draft rules, we have given feedback from ISF. We will definitely do the same thing with other rules as well. So what prevents the government from notifying the effective date is essentially you need rules to ensure that these are how these broad provisions of the Act are implemented, and employees are clear how to follow these provisions. Right. So, Code on Social Security. The overview is that about 13 laws have been subsumed into the Code on Social Security. And if you really look at it, what is the major impact? When it comes to EPF, ESIC, even maternity benefit and gratuity, there are no major changes. It's kind of almost the same provisions have been repeated. Of course, FTE has come in kind of a bit added a certain amount of uncertainty, and some discussions are required. From a gratuity perspective, maternity benefit, there is a bit of a clarification on the creche part of it, because earlier the 2017 amendment came, and creche was made mandatory for employers employing more than 50 employees. There is a confusion as to how do we get it implemented. It's not that there is large clarity, but then the proviso to that particular section does talk about common facilities either created by the government, local municipal authority, or by the industry bodies, or a couple of more than one employer together, and all of this been added. So when the rules come out, hopefully there is a little more clarity from a creche requirement perspective. For us in contract staffing industry, again, do we really fall? Whose responsibility is it? A contractor or principal employer is also another question that needs to be answered. But apart from these, there are no major changes. So ESIC, EPF, all of them are going to be as is. I don't see a major changes. ESIC, when it comes to threshold and then applicability, when do you get registered, there could be changes because the confusion with regards to 20 covered employees or 10 covered employees post 2011 is kind of not there now. It is, if you have employees more than 10, then you have to be covered under ESIC. And if you're handling hazardous process or hazardous material, or you are in an hazardous process factory, even one employee, you need to have a ESIC registration. So that's the other one. And apart from all of these, major highlight for Social Security Code is gig workers. Government has enabled itself with powers to come up with a Social Security framework for gig workers, and defined a few terms to recognize that there is what you call employer-employee relationship, which is outside of the traditional employer-employee relationship. How those things are going to pan out, it will be very interesting to watch out. As Lohit rightly commented on his starting remarks, the major contours, like how this funding will be constituted, which are going to be the funding. They have clearly said a certain percentage of turnover from the platforms, and then certain limit is set on how much is being paid to the gig workers. But how and what are the backbone, who will administer it, etc., is all questions that we need to await for the government to come up with a detailed scheme. So that's the overall initial views. And I will cover a few changes and then what could be their impact. ESIC, I said 10 or more employees. And another important aspect is, earlier, to cover yourself voluntarily under ESIC, if you're not having 10 covered employees or 20 covered employees, is difficult, or it's not possible. The law didn't provide for it, neither in the Act itself nor in the regulations. But now regulations or rules. But now I think the Act clearly provides for voluntary ESIC coverage if you're less than 10 as well. That's a change which has already been there in EPFO, under the PF Act. So that's one change. The EPFO, there is no major change. I think what are going to be the thresholds, etc., we need to wait and see. But the feedback from the government is that they are not going to change anything much from a contribution threshold perspective, etc., etc. So we will have to wait and see when the final rules are framed. Obviously, they are going to replicate the APF scheme 1952, EPS scheme 1995, and EDLI scheme 1976. So all of them are going to be re-promulgated without much of changes, because I don't think government has the time to do the rules as well as drastically change anything with regards to PF ESIC perspective as well. So, but then there are questions on webinars, and then people do ask us at ISF Regulatory Affairs as well as outside, is saying that is the threshold going to remain the same? Will what is going to be the impact of wages? I don't want to get into the wages part, because Vardhan is having a detailed session on that alone, because that has caused enough confusion among employers and contractors and principals. If you look at how the social security provision for gig and platform unorganized workers, it's an interesting chapter there. The chapter kind of clearly enables only the central government to come up with a scheme for gig platform gig and platform workers, which is significant if you look at overall context of these codes and then appropriate governments being defined, etc. And with regards to unorganized sector, the state governments have always also been given powers to come up with this. So that's a recognition of the fact that state governments have already created quite a few funds, social security related provisions and funds for example, Kerala, you will find auto workers or even people who climbed coconut trees. I have a social sector fund set up for them by law and enacted under the Kerala state, by the Kerala state. So in recognition on BOCW today is again, while the act is central, the implementation is by the state BOCW CES boards. So in recognition of that, I think continuing that, I think they have given that powers to continue to be with the state government, giving the powers to central also. But gig and platform workers, it is exclusive power is with the central government. In a way, it is good from a perspective, then there is no confusion that might get resulted. Some of you have asked some questions with regard to all these kind of things. Will it stand scrutiny at the judiciary level, considering this labor is a concurrent subject? It's a very good question. Honestly, how the judiciary is going to view such questions, we will have to wait and see. But I think they will generally look at balance of convenience and the confusion that might get created if each state were to pass different laws and all of that. Probably that is the stand state central will take if at all states were to take a different stand and come up with their own amendments, or it reaches a constitutional bench on how these things have to be decided. But having said that, the way government is working based on our interactions through ISF, etc., it's very clear government is already in close contact with the state governments and trying to come up with rules which kind of gets replicated at the state levels as well. So probably there may not be huge questions around states coming up with their own schemes and their own this thing. We have seen it over the last 70 years. If you really look at it, other than Shops and Commercial Establishment Act, probably Labor Welfare Fund Acts, you haven't seen much activism by states. They just added probably in Factories Act a few safety provisions in their Factories Act provisions. Otherwise, generally the labor laws are central laws and the rules are the ones which has come from the states. And some of the definitions that they've come up with is interesting. I have a separate slide for it. Let's go when we talk about it. And contribution, as I was discussing with regards to rates of contribution from an aggregator, it is what they have said is 1 to 2% of the turnover. With aggregators today, what is turnover itself is a huge question. So we will have to wait for how that will get defined in the rules. And similarly, 5% of the cap being provided on the amount paid to the gig or platform workers. So again, there are questions: is it the gig worker is paid per piece or per task completed? And then in such cases, how will you calculate it? Is it going to be a monthly contribution? Is it going to be contribution per work performed? We don't know. So honestly, we'll have to wait for the discussions to complete. Government has reached out to, is what we believe, all those platform companies, and then they're all in serious discussions with the government. eventually what comes out, we will have to wait and see. Hopefully that's going to be practical, easy for implementation. And the other major aspect that from my perspective the government needs to be careful is how these a person in his life can be a gig for a point of time. From gig he can move to a typical employer-employee relationship kind of a thing, with either to a contract staffing or to the directly to the principal employer, and from there he can kind of say, okay, I got enough experience. He can become a self-employed professional, and from there he can become again come back to any type of work, right? So this transitions need to be taken care of. So when the platform is set up, how such a platform or how such a network of social security arrangement is going to talk to the existing arrangements, that is EPFO, ESIC, and how does an individual transition from his one nature of work to another without without concerns about his money being stuck, and confident that that money which is collected is available for him at the time when he leaves employment, finally is into retirement, are all going to be critical. Because we have, after a long time, we have come to a situation now, I think you can I don't know, with confidence probably say that with your contribution with EPFO, you have access to it, you know what's happening to it, you can carry it with you from one employment to the other without being concerned about what happened to it after the lot of this automation, online enablement has happened. So if you don't do the similar kind of network which kind of talks to each other from NPS to EPS to whatever is your gig platform is going to, it's going to be a if it is not set up, then it will become difficult for the platforms to comply and convince the gig worker saying that they have to pay this contribution, because if he doesn't see the benefit of it, it's going to be. Similarly, the cost of administration of such provisions cannot be too expensive. It can be complicated in the sense that capturing data, ensuring enrollment into the schemes, etc. Even that becomes too complicated. Probably there will be intermediaries like us, staffing companies can go and help there. But if it becomes difficult to convince the gig worker to be part of this, because the whole arrangement is not very transparent, it's going to be difficult. So I think government should be I believe is really looking at it in a with that purpose in mind, and finally the rules and procedures will come out that way. And also the national database effort with regard to unorganized workers, gig, etc., etc. You have seen the provisions in the code which clearly says that Aadhaar will be the basis for it. Again, Aadhaar being the basis raises questions. We are already going through enough pains in the contract staffing network and community, with Aadhaar being the basis for creating UAN. But then there is a constitutional question there. Without central government contributing from Consolidated Fund of India, can that be made mandatory? So government has to come up with, when it finally comes up with the scheme, come up with some at least a token contribution from the government side. So we will have to wait and see how that happens. We have talked about registrations. Again, interestingly, I was on a call with Joint Secretary on, I think it is through ISF or one of the other forums, where they were even talking about current established registrations with PF and ESIC could become the one single registration for all the codes together, even an OSH registration. But we don't know. We'll have to wait for how that's going to come out. Employment information, that's what I dealt with in detail. Gratuity, I have a separate slide, probably we will take it up there. I'm sorry, I'm kind of rushing because there are other speakers waiting, and then we need to have enough time for question and answers in detail as well. So with regard to enabling provisions, I mentioned the definitions providing for outside of a traditional employer-employer relationship. If you look at the definition of gig worker, for example, means a person who performs work or participates in a work arrangement and earns from such activities outside of traditional employer. So this is a clear recognition, right? So one of the biggest problems that we used to face with in ESIC social security officer or enforcement officer from PF is you will never, even in a place where we have hired, let's say, a high-end IT worker on a on a professional services contract, they will always dispute. No, this is a typical traditional employer-employee relationship. And that's where we used to get into trouble. Here, this is a clear recognition that such arrangements are possible. Probably, yes, you might dispute this with me saying, this is more from a perspective of gig workers, those delivery boys, or people like Swiggy delivery boys who do it based on a task-based arrangement with Swiggy or whatever be the platform. But I think I believe this jurisprudence will evolve on this, and definitely the original concept of gig, which evolved from IT sector knowledge workers in your typically in Silicon Valley, where the person who knew how to code and who knew he was in demand by multiple employers and kind of parceled his time out. From there it emerged. I think this is from that perspective, this is a recognition of such gig type of works. So one that is, and the reason I am spending time there is that it's clearly when the final arrangements come, final provisions of how this is going to be implemented, we also see a lot of possibilities for either the staffing companies or also some of the typical employers today having two sets of employees or two sets of workers in their arrangement. One, your typical traditional employer-employee relationship ones, the other one non-traditional. Of course, there's going to be disputes because you have every possibility that the EPFO or the SIC authorities coming and disputing your claim that it is outside the scope of traditional employer, like they dispute now. So it all depends upon how each of us and the employers, how they define this, how they ensure that the master service relationship is non-existent in the other gig workers, gig arrangements, and how do you kind of argue, and how the courts are going to look at it. So we are in for interesting times, but this definitely throws a different challenges and opportunities for your both normal employers and us for standard staffing companies. And the unorganized sector is also interestingly quite a few definitions have come in place. Who is a self-employed worker? And there is also confusion with regards to, I'm going to the slide, home-based worker. And there is a bit of a confusion with regards to home-based worker, and a lot of us doing work from home now, right? So the home-based worker is not the work from home worker, okay? The work from home-based worker is essentially the unorganized worker who is not covered under the provisions of Industrial Disputes Act, is how they have described, as described. So this is different. See, the normal worker who works from home will be, we will have to see how we will cover them. Probably that's where IR code with its standing orders provides an opportunity for us to kind of define some of the provisions in the standing order and cater to that requirement. But this will be different, and I think the home-based worker will all fall under the self-employed, unorganized sector and unorganized worker. And the wage worker who is actually getting the typical wages normally now, but he is engaged by an unorganized sector employer, unorganized sector, which is that less than 10. And now the government has got both at the central and state to provide for social security for a larger sweep of these people. And this will also include probably the domestic workers as well. And center has given itself to power to provide for social security in those items listed: life and disability cover, health and maternity, education, and of course the wider powers to anything else, and state for PF, employment injury, and all of that. So there is a kind of overlap there, because old age protection can be PF as well. So we'll have to wait and see how they are harmonized that, because there are already existing funds under this for these set of workers. How the government is going to create that umbrella organization which is going to govern all of them, and is it going to be under the Pension Fund Regulation Authority Act? We don't know. All of this is something which is kind of hanging in the open for the government to come up with the schemes, and then for all of us to participate and understand, give our feedback, and finally evolve into the next one. All said and done, as I said, clearly it's interesting times ahead. We will have to wait and see the final nuts and bolts of this, how it is. With regards to fixed term employment and the confusion with on gratuity, this emanates from the definition of FTE in IR code, which has a last part of it, which says that you shall be eligible for gratuity if you render service for contract for a period of 1 year. But at the same time, that point C is not there in the definition of a fixed term employee in the Social Security Code. So the question now is it mandatory that person has to complete, even if it is, what if the fixed term is only for 6 months? So if you go into the provisions of the gratuity chapter relating to gratuities, they've just cut paste, they just added the same existing provisions and said that with regards to FTEs and the death and disablement cases, the 5-year term will not be applicable. Then they've gone on to say, which is again a reproduction of the earlier section, which says that the employees who have served for more than 6 months is eligible for gratuity. But then there is a new proviso, or the existing proviso they've added where it says with regards to FTEs, it needs to be prorated. So there is a whole lot of confusion now. I don't know whether that will get clarified in the rules. Probably it will be. But the question now, I've seen already a lot of them asking the question. So FTE, if he is less than 6 months off term, let's say 3 months contract, will he be eligible for it? Going by the proviso which I already talked about, I think they will be eligible for it. So I think while we will wait for the clarity to emerge in the final rules, I think as principal employers and contractors and people who are going to look at FTE as an opportunity and an option to provide for project related works, I think it will be better to be bracing yourself for that gratuity as a cost, even in a contract less than 6 months, and provide for that and ensure that it gets paid. But we will wait for the final rules to come and then interpret that further. I had only that much. Of course, there are enough and more items that points that can be discussed. But I will leave it, yield it back to Suchita for the next speaker. Obviously, we are always available for you to answer, and we will also attempt to answer all questions which you.
Thank you so much, Madhu. Yes, for keeping the timelines for such a difficult and long subject, but I'm sure the questions will be more than adequate to take up the time that we will save over here. May I request Sushil from GI Group, Head of Compliance and Legal, to look into the Code of Wages from a highlights perspective. The Code of Wages obviously came in 2019, but yet the rules and the framing is going on. So if we could have that into 2 parts as we have planned, the definition part, I would request Mr. Vardhan from Aprajita, Chief Consultative Officer, can take up the questions which is related to the definition, and the highlights, if I may request Sushil to take up. Sushil, over to you, please.
Yeah, thank you, Suchita. I'm very privileged to be part of this exciting this webinar. And I will be covering the topic Code on Wages, which was actually enacted last year in 2019, and the rules are still underway. So I would just like to brief you what are the topics I will be covering. So first, I will be covering how the codes evolved, in which I will be giving a brief background. And second, it will be in the words of Honorable Union Minister, Labour Minister Sri Santosh Kumar Gangwar. So in this, we will be covering what reforms the Code on Wages promises to bring in. Next, it will be what the consolidation means to India and Indian industry. And then we'll see what are the historic mergers under Code on Wages. And later we'll see how the code features into various chapters, provisions, and sections. Here we'll see how many chapters are there, and what are how many total provisions are there, along with the total sections as compared to the earlier 4 acts. And the last one will be key highlights of the Code on Wages 2019, in which I'll be briefing all the acts which are merged into Code on Wages. So I'll just take you through my presentation. So here it is, how the codes evolved. So as you can see, there was first tripartite consultation was held with between trade unions, employers, and state governments. That was back in 10th March 2015. And thereafter, on 21st March 2015, a draft labor code was placed for public consultation, which is a general practice that in case any law is to be passed, the government usually goes for public consultation. Next, on 13th April 2015, second tripartite consultation was held, the same between trade unions, employers, and state governments. Thereafter, on 10th August 2017, the bill was first introduced in Lok Sabha. And then on 21st August 2017, bill was referred to Parliamentary Standing Committee, in which the matter was discussed. And on 18th December 2018, Parliamentary Standing Committee submitted its report, that what are the modifications they required and what are changes they need to bring into. So finally, on 30th July 2019, the bill was passed in Lok Sabha. And then on 2nd August 2019, the bill was finally passed by the Rajya Sabha. And on 8th August 2019, the bill received President's assent, and obviously it became an act. So this was the brief evolution of the code. So here there are like a lot of speculation going on, and we get some queries also. So what is the date of enforcement of the code? So if we refer section 1.3 of the Code on Wages Act, Code on Wages 2019, it mentions that it shall come into force on such date as the central government may, by notification in the official gazette, appoint, and different dates may be appointed for different provisions of this code, and any reference in any such provisions to the commencement of this code shall be construed as a reference to the coming into force of that provisions. So this basically refers to that the code is yet to be enforced, because as you can see, central government reserves power to implement the various provisions of the code on different dates. And even they have reserved the power to implement this on like phase-wise manner. Like some provisions will be implemented in X date and other will be implemented in Y date. So they have reserved this provision. So we'll move on with the next. So this is basically what Honorable Labor Minister Santosh Kumar Gangwar has to say when the code was passed. So among the four acts being subsumed, the Code on Wages 2019, the payment of wages 1936. As you can see, it was passed in 1936, which belongs to pre-independence era, and the Minimum Wages Act itself is 72 years old. Hence, since these are like very old acts, so the need for consolidation and reform was like very necessary. So we have finally got to see some very historic changes. This code ensures that minimum wages, along with timely payment of wages to all employees and workers. Many unorganized sector workers like agricultural workers, painters, person working in restaurant and dhabas, chowkidars, etc., who were out of the ambit of the minimum wages will get legislative protection of the minimum wages. This is what this Union Labor Minister Santosh Gangwar has to say once this code was passed. Next, he also mentioned that there is right to sustenance. Like for every worker and intends to increase the legislative protection of minimum wage from existing about 40% to 100% workforce. In his basically the right to sustenance is because it is the right to earn living. So in this, by passing this specific code, the Union Minister has specifically mentioned that the right to sustenance has been enabled, and this will help like 100% of the workforce to get legislative protection of the minimum wages. Next, he has to say that introduction of statutory floor wage to be computed based on minimum living standard, which will extend qualitative living conditions across the country to across 50 crores workers. So this is what the code boasts of, and in which they will getting 50 crores workers will be getting this benefit under this statutory floor wage. Next, we can see what the consolidation means to India and Indian industry. So as you are aware that there are 4 labor codes, out of which Code on Wages was passed last year, and remaining all 3 codes has been recently passed in September 2020. So in totality, 29 acts are subsumed under these 4 labor codes, which boast of simplification, rationalization, and less cumbersome. It further advocates on reducing complexity in compliance. Code and wages is one of them, which is merger of like 4 acts. So code and wages is basically one of the code, which is merger of 4 acts, which we'll see later on what are the 4 acts which has been subsumed into code on wages. So here we can see what this 4 codes means to India. So currently, if we can see, India is ranked 63 in ease of doing business as per doing a business 2020 report. And with the consolidation of various labor acts, the ranking is expected to improve, and India is expected to make a breakthrough among top 50 countries. So itself, we can see by passing all this enactment of all these 4 codes, the ease of doing business, the ranking has been improved quite a lot as in context to earlier acts. So we'll move on next. What does the consolidation of various acts means to India? So it will basically a healthy move towards employment generation without affecting rights, health, safety, and security. So this will be these codes will basically help in employment generation, but this will not hamper employees' rights or health safety and any security of the employees or workers. So this will basically next it will basically reduce the compliance cost as various returns, registers, licenses as merged which were prevalent under various earlier acts. And next will be like digitization of activities. So as we can see, we are in digital era now, and even all the payments and all these things are made digitally. So government has specifically focused on digitization of various activities such as inspection, license, procurement, etc. to bring better transparency. Surely digitization of activities will bring better transparency, and we have to not hover around like various departments manually. So these are the historic mergers, if we can see. So the 4 acts, Minimum Wages Act, Payment of Wages Act, Payment of Bonus Act, and Equal Remuneration Act. All these 4 acts has been subsumed into one, that is Code on Wages 2019. The rules are yet to be passed, and it has already been framed, but under like process of getting this enacted. So what this historic mergers brings in, we can see the comparison. So in earlier 4 acts, there were like total 115 sections. And under Code and Wages we have 69 sections. If we see the rules under all these earlier 4 acts, there were 67 rules, and currently we have 58 rules. So returns, if we see, there are 3 returns under Payment of Wages Act, Payment of Bonus Act, and Minimum Wages Act. But if we see in Code and Wages, that will be subsumed into one return only. If we see the registers, there were like 14 registers in all these 4 acts, which has been now subsumed into only 3 registers. So that is like a big changes as far as compliance is concerned. So the major thing that we can see is the like subsumption of like various definitions. If along in the 4 acts, if we see, there are like 46 definitions, which has been now subsumed into only 26. So this is basically like simplification and bringing transparency in the compliances. Abstract, if we see, there were 2 abstracts under like Payment of Wages Act and Payment of Payment of Minimum Wages Act, but now it will be like a single abstract under Code on Wages. Next, we'll move on how the code features into various chapters, provisions, and sections. So if we can see, there are a total of 19 chapters and total of 69 sections. So first chapter contains of preliminary, in which it will be like out of the 4 acts which has been subsumed, Equal Remuneration Act contains like 2 sections, basically sections 3 and 4. So that is under section 3 and 4, Equal Remuneration Act. Next is Minimum Wages Act, that is under Chapter 2, in which there are total of the sections vary from 5 to 14. And under Payment of Wages Act, that is under Chapter 3, and the section are from 15 to 25. Similarly, Payment of Bonus, it is Chapter 4, and Advisory Board Chapter 5, Payment of Dues, Claims and Audit under Chapter 6. Inspector cum facilitator. Yes, this is one of the new thing that has been brought in. Earlier, we used to see that only there was like some nomenclature called inspector. But now government has thought of something, and they have brought in a new designation, inspector cum facilitator, which we'll see later on. So that is under Chapter 7. And next, under Chapter 8, we have offenses as penalty. And last will be Chapter 9, miscellaneous. Now next it will be key highlights of the codes. Now we'll see. As we can see, there are like four subsumption of four acts. So Equal Remuneration Act already covered under section 3 and 4 under preliminary chapter 1. Now we'll see under minimum wages. So as you can see, central government vests power to fix the national floor wage. However, the power to fix the minimum wages vests with appropriate government. So we are just, as we have seen from various speakers, that the word appropriate government has been used. But we need to see what the appropriate government basically refers to. So as you can see, appropriate government means in relation to an establishment carried on by or under the authority of central government, or establishment of railways, mines, oil field, major ports, air transport service, telecommunication, banking, insurance company, or a corporation, or under or other authorities established by a central act, or a central public sector undertaking or subsidiary company set up by central public sector undertaking or autonomous bodies, owned or controlled by central government. So basically, we can see that various like the central government related bodies are covered under Central Act, and apart from that, in relation to any other establishment, that will be the state government, who will be the appropriate government. So minimum wages continues. So the major thing is the definition under minimum under this code, that will be the wages, which will be like dealt by our co-speaker, Mr. Vardhan. So as you can see here, the XRA has been specifically excluded from the definition of wages, that is under section 2Y. Further, wages has been well defined with motive to pluck loopholes. However, some clarification required to determine remuneration. So the clarification is still to be there in determining the remuneration, which will be dealt later on. The wages definition shall be common across all the codes and has huge impact. That's for sure, because under all codes, what we have learned so far, we can see that this definition of wages is one of the major things. So as I told, this will be dealt separately by our co-speaker, Mr. Vardhan. Next is the minimum wages of the minimum rates of wages fixed by appropriate government shall not be less than the floor wages. And if the minimum wages of minimum rates of wages fixed by the appropriate government earlier is more than the floor wages, then the appropriate government shall not reduce such minimum rates of wages fixed by it earlier. So this basically refers to that minimum, the power to fix the floor wage rests on central government. Now, but in case that rests on central government, but appropriate government has power to determine the minimum wages. So in case the state government already have fixed the minimum wages that is exceeding the floor wages that has been determined by appropriate government, and surely this state government cannot reduce such minimum rate of wages as compared to that they have determined earlier. So we'll move on to next one, and that is payment of wages. So the key highlights here will be like monthly wage payment before expiry of 7th day of the succeeding month. So earlier we have seen that there were like 2 dates, like for establishment less than 1,000 worker, it was 7th of every month. But in case of more than 1,000 worker, it was 10th of every month. So, and full and final settlement within 2 working days of separation. So this is also one of the change we can see under Payment of Wages Act. So that is already covered under section 17(2). And this payment of wages applies to all employees of the establishment. Earlier, it was applicable to employees drawing wages less than 24,000 only, but now this will be applicable to all the employees of the establishment. Next is the total amount of deduction in any wage period from the wage of person employed shall not exceed 50%. So this is for overall for every establishments. But now earlier it was like for cooperative societies, this percentage was 75, which has been reduced now. That can be referred under section 18(3). We'll move on to payment of bonus. So this is applicable to 20 or more persons in any accounting year. However, the code is silent about continuity of applicability in case the count falls below in a subsequent accounting year. Like earlier, we had the provision that in case the count falls below 20, and the code then the act continues to apply. But in the code, this is completely silent. So we need to see in case there is any clarification, or in case there is any in case any their rules formulated under this. Next is the it empowers appropriate government to determine ceiling of wage limit for eligibility and calculation of bonus. So we have seen what appropriate government means. So this power has been given to this power has been given into the appropriate government. This is basically state government in most of the cases, to determine ceiling of wage limit for eligibility and calculation of bonus. Next is payment of bonus to be made by crediting it in the bank account of the employee within a period of 8 months from the close of accounting year. So this basically leaves the provision of paying a bonus through check. So we have to directly credit into the bank account of the employee concerned. So in earlier provision, there were there were various disqualification related to non-payment of bonus. So in the current code, another disqualification has been added, which is conviction for sexual harassment, which will be one of the reasons for now for disqualification of bonus. So we have covered this too, and next will be like other highlights that will be like miscellaneous and other all, including penalties, offenses, and all. So this code provides for compounding of offenses which are not punishable with imprisonment. So compounding of offenses is possible now, but that should not be punishable with imprisonment. In case of claims filed related to non-payment of wages, non-payment of bonus, payment of reduced wages or bonus, any unauthorized deduction, the burden of proof shall vest with the employer now. So now employer has been given all the burden in case any employee or worker files any complaint related to non-payment of wages or non-payment of bonus or reduced wages or bonus. And in that cases, employer vests the responsibility to prove that yes, he has actually paid complete wages, or actually he has paid complete bonus or not. Next is existing limitation period, which currently hovers around 6 months to 2 years, has been enhanced to 3 years. So the limitation period for like filing of cases and filing of like any cases we have the earlier period, it was like 6 months to 2 years, but now this has been enhanced to 3 years, like giving the workers and employees ample time to file their cases with the employer or the relevant authorities. Provides for graded penalty for various contraventions. In other words, penalty increases in case of like subsequent contraventions. So as we can see, like as compared to earlier provisions, like now in currently in under code on wages, we have like provision for graded penalty, in which like in first offense the penalty might be like a bit on lower side, but that keeps on increasing if the penalty is like if the offense is made subsequently on like first, second, or third consequences. earlier we read about like a inspector cum facilitator. So now under this codes, there will be appointment of inspector cum facilitator as against inspector, which will remove malpractices and strengthen compliances. So the facilitator here basically will be who will ensure that employers are adhering to the compliances instead of like taking strict actions at straight away. They will be like give ample opportunity to employers to just follow the compliances as per the relevant law. So I have tried to make it very crisp considering the time constraint. So any query on this will be like happy to take on. So thank you.
Thank you so much,
Thank you,
Sushil.
Sushita.
Thank you for not only just giving us a lot of insights, and obviously the questions are coming in for us to take it up in a little more detail, but I think a lot of highlights have been captured very interestingly. I think the most interesting part again and the most confusion that has come up are the definitions from the Code of Wages.
Exactly, yes.
So if I may request Mr. Vardhan to kindly take up the panel discussion from here, not the panel discussion, sorry, for the discussion on the Code of Wages, and over to you, Mr. Vardhan. Thank you so much. Thank you, Sushil.
Yeah, thank you, Sujita, and thank you, ISF, for the opportunity. And I would like to place my appreciation to all the earlier speakers, Suhas, Unni, Madhu, and Sushil, for their excellent consolidation of all the four cores. And my job is more focused only on wages, in fact. So the term wages, actually, it is defined in all the four codes, and the definition is common, right? I think it is section 2Y as far as code on wages is concerned, and 288 social security, 2ZZJ for occupational safety code, and it is 2ZQ for industrial relations code. And the definition is same. And maybe I think we have got a bit of clarity, as well as still there are gray areas. Let me take you by way of giving some examples. That is my idea. But before that, quickly I have captured the definition. The definition has all the 5 parts. Substantive part is there, inclusion part is there, exclusion part is there, provisos are there, explanation is there. Right? Again, in the exclusion part, I think I would like to draw your attention to the serial number D, F, G, and H. I think red color, red font. Any conveyance allowance, house rent allowance, and remuneration payable under any award or settlement, any overtime allowance. All these are excluded only for the purposes of payment of wages and bonus. Minimum wages and bonus. For the purposes of payment of wages and equal remuneration, all these 4 components are to be included, actually. That is number 1. Number 2, the bold lettered classes, class A, class C, and class G. Let me see why I've made it as I have highlighted this. I'll just go to the next slide. Maybe for explanation purpose, for 1 or 2 times I may go back and forth more to explain, right? So this is proviso class. The proviso says again calculating the wages under this class. Again, if payments made by the employer to the employee under clauses A to I, right? If it exceeds 1/2, which means if it is more than 50%, I'll go back to the previous slide. So when they say A to I, clearly class J and class K, they are excluded. That is, gratuity is clearly excluded, and any retrenchment compensation is very clearly excluded. Only the sum of the components mentioned from classes A to I think the total sum of these classes, if it exceeds 50% of the total remuneration, then the excess amount will automatically be treated as wages. That is what this particular definition says. So my point here is again class A. Class A is not a monthly payment. It is a bonus payment. It is an annual payment, and the payment arises irrespective of whether it is getting mentioned in the CTC or not, because of the operation of the some legislation, which is here the Payment of Bonus Act. Right? I'm not very sure why it is brought here. Similarly, any contribution paid by the employer to any pension fund or provident funds, so class C, right? So which this this indirectly means for calculating the total remuneration, in the first place, we may have to add these three components also, class A, class C, and class G. And I think more interestingly, remuneration payable under any award or settlement, class G. I'm not still very sure why it is getting excluded, because every company, I think particularly factory sector, where they have unions, very active unions, I think the settlement will happen once in 3 years or 4 years or 5 years. And the salary structure will also get revised based on the agreement between the management and the unions, right? But this remuneration payable under any award or any settlement, I think it is very open, it is very wide. Why that is getting excluded as salary? What exactly is meant by these terms? I am still not very clear. So this A, in my opinion, the class A, class C, and class D, I think that those classes should also be excluded, like class J, that is gratuity, and class K, any retrenchment compensation. If that is done, I think there will be more clarity. Because since that is not done, I think for going ahead, if the commencement is announced by the government anytime, whether it is in December or in April, right, there could be a problem for the employers, because unless and otherwise there is some guidelines issued by the department concerned, right? So I'll just again move ahead. So mathematically saying, there are two key terms. Two key terms. One is remuneration, and the second one is wages. So to arrive at what exactly the quantum of wages, first we may have to ascertain the remuneration. So remuneration is equal to whatever is mentioned in the substantive part of the definition, whatever is mentioned in the inclusion part of the definition, whatever is mentioned in the exclusion part of the definition, that is from classes A to I. All these three are to be added, right? That will give the total remuneration. Then from the total remuneration, we may have to deduct the exclusion part, that will give the wages part, right? So if at all, if I should be very clear about the quantum of wages in my salary structure, then in the first place, I should be clear about the remuneration, right? But I think because of the wordings in the proviso, the employers will tend to naturally include class A as well as the remuneration as per the settlement or the award, and as well as the employer's contribution towards PF. I don't think these three can be added, considered as wages, because these are all, I think these are all in the totally different arena actually, that cannot be compared with the monthly wages which is committed by the employer as per the agreement, that is the contract of employment. Now it is a clear example of a very simple salary structure: basic, DA, HRA, conveyance allowance, and commission, right? So basic is 5,000, and all the other four components are 2,000. It is just for example I have given. So the monthly gross comes to 13,000, right? So then PF employers contribution, it is 840. That is 12% worked out on basic and DA. Similarly, ESI employers contribution 228, because HRA, conveyance allowance, commission, all the three are excluded, right? So I have not taken that, both for the purpose of PF as well as for the purpose of ESI. And for bonus purposes, again 1,400. Again, it is only for example. So 20% of 7,000 per month, reckoned per month. So that total gives 15,468. Now we have two figures. One is 13,000. Another one is 15,468. So which one should be considered as remuneration? Should I consider 13,000 as remuneration, or should I consider 15,000 or 468 as remuneration? I think because by the wordings given in the proviso of the definition, I think people will naturally tend to take 15,468 as the remuneration. But I think that cannot work properly actually. I would again draw your attention to the right side. So what is the total remuneration, whether it is gross one or gross two? Assuming again it is gross one, say 13,000, which means 50% of 13,000 will work out to 6,500, right? So the sum of basic and DA alone is 7,000. 7,000 is more than 6,500. That is, it works out to more than 50% of the total gross, which means this structuring is proper, right? On the other hand, if I assume that gross 2 is the total remuneration, so there I may have to exclude the contribution towards ESA, because that is not mentioned there. So I will take only 840 and 1,400, and I will leave out 228. So which will that gives 15,240. So for the total remuneration of 15,240, the 50% works out to 7,620. right? But sum of basic and DA, it comes to 7,000 only. So which is much less than 7,620, which so the basic and DA total sum is below 50%. So automatically 620 rupees will automatically be treated as wages, part of wages. So that is how this will work as per the definition. But what is not clear here is, should I consider gross 1 as the total remuneration, or the gross 2 as the total remuneration? Unless and otherwise some clarity is given by way of notification or by way of guideline by the department concerned, it will be highly difficult when the code gets implemented. I'll move on. This is very specific to minimum wages. I think we all discussed that HRA is very clearly excluded now, right? So now assumption is minimum wage is 10,000. So the salary structure is basic, DA and HRA. 6,000 plus 3,000 plus 3,000. The total works out to 12,000. As per the current provisions of the Minimum Wages Act, right? So wages will be considered as 12,000, because we all know the judgment given by the Apex court in ad freight case as early in 1998, that we may have to exclude all the components which are very clearly excluded under the definition of the term wages under Minimum Wages Act. So rest of the components we can include, right? Now HRA is included as per the definition of the term wages under current Minimum Wages Act. So the wages will come to, so entire monthly gross, that is 12,000, will be, in this example, will be considered as wages. So which is much higher than 10,000. So we are paying more than minimum wages. So this is fine. But as per the code, HRA is excluded. So that will not be treated as wages. So the total wages is only 9,000. So this structure will not work. So it is less than 10,000. So therefore there is a shortage of 1,000 rupees. Right. So this structure may not work if the code comes in this, maybe whatever fashion it is available. And specific to bonus, again, basic, DA, HRA, conveyance and commission, 10,000, 4,000, 5,000, 5,000, 5,000, total comes to 29,000. Again, we will consider maybe basic and DA, total comes to 14,000, right? But 50% of the monthly gross will work out to 14,500. I have assumed that the monthly gross, that is gross 1, as a total remuneration. Based on that, I am moving ahead. So here, so the 50% comes to 14,500, but the basic and DA alone comes to 14,000, which is less than 14,500. So less than 50% of the monthly gross, because HRA, conveyance allowance, commission, all these components are clearly excluded now. So deemed wages in that situation would be 14,500. Right, so which is less than 21,000, which is the current ceiling for determining the eligibility of the individual for payment of bonus. So this person is eligible because he is drawing less than 21,000, but calculation will be made on 7,000 or minimum rates of wages, whichever is higher as per the current position. If you go through the section 12 of the current Payment of Bonus Act. Right. So here also the structure is not proper because the basic and DA is less than 50% of the total gross. Right. Let us understand that. But for the purpose of bonus, if we have a structure like this, then automatically we may have to consider wages for the purpose of bonus as 14,500, which is the 50%, because there is a cap now fixed through this new definition for the excluded components. So excluded components cannot go beyond 50%, even if the salary happens to be 1 lakh, right? So at least 50,000 will automatically be treated as wages for all purposes, not only for subject to, of course, ceiling. If there is any ceiling specifically mentioned for PF, then we may have to go as per that. If there is some ceiling mentioned for the purposes of ESA, then we have to take that into account. Otherwise, if we are just have to calculate the wages alone, then I think it should be 50% of the monthly gross at least. It cannot go below that. Then PF, I think basic, DA, HRA, conveyance and commission. Again, the total monthly gross comes to 34,000, but basic and DA alone is 12,000 plus 4,000, which is 16,000. But 50% will work out to 17,000. So this 16,000 is much less than 17,000. So this structure is not proper, but PF wages or the deemed wages would be 17,000 as per the new definition, right? Of course, the employer can contribute for the entire 17,000 because 17,000 is the PF wages, or he can restrict it to 15,000, which is the current ceiling, right? Because I think they have clearly said till such time the new schemes are announced under the code, particularly for PF, I think the existing PF scheme will continue. So we can now restrict the contribution to 15,000. instead of 17,000. That option is available for the employer. Coming to ESI, again, basic DA and HRA, total comes to 24,000. So the 24,000 means currently, I think it is more than 21,000, which means he goes beyond the ceiling. So this person need not be covered under ESI at all, right? But for the purpose, as if we apply the new definition of the term wage, I think we cannot take into account HRA, which means the total comes to only 18,000, which means that is less than 21,000, then this person is to be covered. So the new definition, because of the application of new definition, the position is very clearly changing. So we need to be very, very clear as to what are all the components which are to be excluded, what are all the components which are to be included, and we should be again very careful that the excluded components total sum cannot exceed 50% of the monthly gross at least. Now, for the purpose of gratuity, again, 12,000, 4,000, 6,000, 6,000, total comes to 34,000. Again, basic and DA alone 16,000, which is less than the 50% limit of 17,000, right? But for the purpose of gratuity, again, it would be deemed as 17,000. So if a person gets terminated for any reason, I think getting this salary, having this salary structure, then gratuity will be worked out, keeping 17,000 as his wages, right? Not 16,000. But currently we will work out only for 16,000. That is agreed as per the current provisions of Payment of Gratuity Act. But the definition of the wage, new definition will change the position now. Then I think other possible, I think these are all certain, I think these are all important legislations, PF, ESI, bonus, minimum wages and gratuity. That is the reason I have come up with specific examples for that. And of course, when we say the other impacts because of the new definition, yes, a cap is fixed for the excluded components. This is the first time this is happening, right? I would say it is one of the main reasons is the employers, right? We as employers, in fact, we give 1 lakh as monthly salary, of which one basic will work out to only 5,000. Rest 95,000 are all allowances. Allowance 1, allowance 2, allowance 3, allowance 9 allowances we will give. Some naming we will do, and we will say that these are all allowances and that will get excluded for the purpose of all the legislations. So we will take only basic 5,000 for the purposes of PF or gratuity or bonus. I think now a restriction is brought in by way of the new codes. And as I said in the beginning, the second point, exclusion of remuneration payable under any award or settlement. I am not very sure what is meant by this, because through the settlement, yes, salary structure is revised, right? Why? What is getting excluded? What quantum is to be excluded? What exactly is meant by this? I'm not very sure. I think some clarity is required. Again, if at all, if we have to stay compliant with the new codes. And gratuity is, I think that is one interesting point, and that is one clarity which is given to the employers. Now, if you go through the definition of the term wages under the Payment of Wages Act, there is some gratuity which is included in the inclusion part of the definition. At the same time, some gratuity which is there in the excluded portion also. If you go through the definition of the term wages under the current Payment of Wages Act, right? Fortunately, unfortunately, in Madras Fertilizers case, I think if I remember right, it is Justice Sirpukar. He gave the judgment holding that this gratuity paid at the time of termination, that should be treated as part of wages. So he took it to the inclusion portion, right? That is the reason that is considered as wages, at least in Tamil Nadu today in the industries. Again, that is the reason. Again, if the contractor fails to pay gratuity, then the liability goes to the principal employer. But this may not be the situation in other states. But now clarity is given. Very clearly, gratuity is excluded. So automatically, when this code is implemented, the decision given by Madras High Court in Madras Fertilizers case will automatically get nullified. And 50% of the wages shall be equivalent to or more than the. We all know, again, air freight case, it clearly says, except all those components which are clearly excluded as per the definition of the term wages under the Minimum Wages Act, you can include all the other components, and if that total sum is equivalent to or more than minimum rates of wages, then that is considered as sufficient compliance. That is what the principle laid down by the Apex Court in air freight case. Now, if we are availing the maximum limit of 50% as excluded components in the new structure, particularly after the implementation of the code, then the remaining 50% will alone be treated as wages. So we may have to ensure then that 50% works out to or more than minimum rates of wages, right? So position is very clearly changing. Right? The principle laid down by the apex court is not changing, but position is now changing. Instead of 100% of gross wage earlier, now it is going to be 50% of the gross wage because of the new change definition. But of course, for the purpose of maternity benefits, now we will be considering the entire 100% gross wage. But now I think because of the change, again, we can consider only the 50%. Similarly, with respect to employees' compensation also. Now we have to consider the entire monthly gross. Instead, it is sufficient to be consider only the 50% of the monthly gross. But of course, there is a ceiling which is 15,000 currently. If that is available, then I think we can avail that. And I think Mr. Sushil discussed about this, both floor wages and minimum wages. There are two concepts again. One, the floor wage. Floor wage will be fixed only by the central government. That is number one. Number two, floor wage will not be uniform across India. It can vary geography wise, right? And the minimum wages will continue to be fixed by the appropriate governments, the central government as well as the various state governments. But the point here is, the catch is, the minimum wages cannot go below the floor wages announced by the central government. I think currently we have a concept called national floor level minimum wages, which is every year the central government is announcing, but this does not have statutory mandate as of now. But in my work, I think if I'm right, it is Puducherry alone, that state alone, they are following it religiously. In fact, in other states, I think it does not have any statutory mandate. Now that statutory mandate is given, but it will be now termed as mere floor wage, and minimum wages cannot be fixed below floor wage. Then full and final settlement, it is to be made within 2 working days. Even today, that is the position. When a person's services are terminated, the final settlement is to be made within 2 working days. But that does not apply for termination due to resignation, because resignation is not considered as termination. It is a voluntary act on the part of the individual worker or the employee, right? But now in the code, it includes resignation also. So whether it is VRS or it is retirement or it is dismissal or it is resignation, the full and final settlement is to be made within 2 working days. And of course, the monthly wages, now we have option. If the industrial establishment has less than 1,000 workers, they have to pay the salary within 7 days after the end of the calendar month, that is the wage period. If it goes beyond 1,000 workers, then I think they can go up to 10 days. Now that is removed. It is only one option available now. In whether it is less than 1,000 or 1,000 or more than 1,000 workers, the industrial establishment has to make the payment within 7 days after the end of the wage period, that is a calendar month again. Then the contractor's payment shall be ensured by the company before the contractor makes the payment of wages. I think it is again an interesting point, but this is coming through the draft rules issued under the code on wages. This is not yet true, but let us be aware of this. So now I think since many of the contractors themselves are legal entities, they are not waiting for the consideration to be received from the principal employer to make the payment of wages to their workers. They are not waiting for it. But now I think there is a mandate given for the principal employer. So principal employer has to pay the consideration to the contractor in the first place, and only out of that consideration, the contractor has to make the payment of wages to his workers. I think the idea of contractor, engagement of contractor is that only, but somehow maybe as days passed by, I think the practice got changed. Now it is now mandated through these codes. Yeah, I think you are seeing a jar in your screen. It is labeled as sugar. See, even now, I think most of us now, when we talk to others, we say just the Supreme Court has said that allowances are also to be treated as wages. Definitely, that is not the case. If those things are really allowances, because when we say allowance, that is a contingent payment. There must be some contingency. Clearly, overtime is excluded. See, all the persons are entitled for overtime, but opportunity may not be given to all the workers. So it is not considered as wage at all, right? So some when we say again conveyance allowance, well, if the for commutation between home and the factory or the workplace, then I think conveyance allowance can be paid. But if some fixed amount is paid without any change, or maybe it is not in the nature of reimbursement, then I think that will be treated as wages. So the point here is, the jar is labeled as sugar. So normally we used to believe that what is inside is sugar, but after the inspection, it is found out what is inside is salt. It is not sugar. So whether the authorities or the courts of law in India, they will not merely go by the nomenclature. So they have the rights to lift the wheel and look ascertain the fact. Right? Let us keep this in mind, because even today, if we have allowances in our structure, the salary structure, that will definitely get excluded. That will not be treated as wage at all, provided it is allowance in its real sense. Right? So when we say attire allowance, uniform allowance, I think people are giving, industries are giving, but it is some flat amount. It is every month it is ritually given. Then that will not be considered as allowance at all. So that is how it is to be looked into. Then I think I've come to the last slide. So some consolidation of these, all the four codes, not only the code on wages. So on our left, certain things which could be considered through these codes, which could be in favor of employers. The mass casual leave, now that could be considered as a strike. And if there is some willful go slow, I think that will be treated as unfair labor practice on the part of the worker, right? And of course, we all know, I think Unni also discussed when he discussed the provisions on occupational safety for factories. If the manufacturing process is carried out with the aid of power, then minimum 10 persons are required, 10 workers are required. If it is done without the aid of power, then 20 minimum number is required, right? This 10 and 20 is getting revised to 20 and 40. Similarly, for the applicability of contract labor, instead of 20, both for the establishment as well as for the contractor, now it is going up to 50. Then for retrenchment and layoff, I think chapter 5B, famous, we used to say that phrase, chapter 5B, but they have used the term industrial establishments there. It will be applicable only for factories, plantations, and mines. Right? If they have 100 or more workers in their industrial establishment, then they have to get permission from the authority concerned. Now that 100 is getting revised to 300. Similarly, for certification of standing orders, which is again a central legislation, it is 100. That 100 is getting revised to 300. Right? So maybe all these can work in favor of the employers, and more importantly, the flexible employee. I think industries have been asking for flexible employment for quite some time. It was there earlier from 2003 to 2007 in the central model standing orders itself, but then that was withdrawn, in fact. But one or two states still continued. If I'm right, it's Madhya Pradesh and Rajasthan. I'm not very sure. But again, I think we have two types of flexible employment. One is contract labor. Another one is fixed term employees, right? But of course, contract labor that we are practicing, but of course, subject to the governing legislation for that class of worker called Contract Labor Regulation Abolition Act, right? But this flexible employment, I think directly, this is a direct employment, direct employer-employee relationship, but we can recruit persons for a specific period. But they are to be treated on par with the regular employees, and they are entitled for all the benefits, including gratuity, on proportionate basis. That is the condition again. Then common definitions, like we saw for wages, even for other key terminologies, I think the definitions, even though it is there in all the four codes separately, it is common for all the four codes. And the recognition of electric record, I think we toiled a lot with the labor department for quite some time. They were in fact never accepting when we maintain registers in the electronic form. But now I think they have started, and through these codes it is pushed, right? So leveraging on technology, we are now employers are now permitted to maintain electronic records, and online processing is also promised. That should ideally ease the process. Number one, that should bring in transparency, accountability, uniformity, consistency, and of course time-bound completion of the work. And ultimately, that should have a check on the undue advantage taken by some of the stakeholders, right? Then reduction in volume of transaction activities. I think somebody showed that the number of registrations, it is coming down. So now if you take the occupational safety code, there are 13 legislations subsumed in that one code, right? Of the 13 legislations, we have to do 6 separate registrations. Now it is sufficient if we have one common registration. If that registration is done under this occupational safety code, no separate registration is required even under the code on social security for PF, Because under code on social security, again, we have to do separate registration under PF, separate registration under ESI, all those stuffs, right? I think it is getting number of registrations, it is getting reduced. Number of licenses, it is getting reduced. Number of statutory registers to be maintained, it is getting reduced. So transactional activities somehow through these codes, it is getting reduced, and the deemed approval provisions. So if I make an application for a certification of my draft standing orders, if I don't receive any information within 60 days, then it is deemed to have been approved, right? That is also brought now. And provision for compounding of offense, I think only for the first time, right? But that should help the employers. On the right side, yes, contribution to reskilling. The reskilling fund is introduced under IR code, right? So the persons, the workers who are retrenched, apart from paying 15 days wages for every complete of service as compensation to the individual, the employer has to pay 15 days wages alone to the reskilling fund, right? So who is the authority? How it will be administered? I think we have to wait for further notification or guidelines. Then compulsory recognition of trade union. I think again, if there is a sole trade union, then that will be considered as a recognized trade union automatically. And if there is multiple trade unions and the one trade union has more than 50% of workers as its members, then that should be recognized actually. But none of the trade unions has more than 50% of workers support, then I think the employer has to form a negotiating council, right? It is to be formed in the ratio of one representative for every 20% of the workers. That is how it is. And yes, labor law, again, it is a branch of law. The beauty of the subject itself is interpretation. So the element of subjectivity and the room for interpretation will always continue. But if it is less, then it will be easy for going ahead with the implementation. And of course, there are certain anomalies. If you go through the chapter 1 part 1 of chapter 11 of occupational safety, which discusses about contract labor, right? It clearly says for the application, it is made applicable only for the manpower supply contractors. Job contractors are missed out. But at the same time, it is in section 45, right? In section 47, the license is prescribed for the contractors. There they have mentioned both. That is, license should be taken by the manpower supply contractor as well as the job contractor. Similarly, if you go to section 2, I think in the definition also they have given both the manpower supply contractor and the job contractor. But I'm not very sure why it is missed out in the application part. Is it an error or is it an intentionally done thing? I'm not very sure, but that should get corrected again. Then bonus. Again, a bonus, it appears that the applicability of bonus portion, it is to be verified every accounting year, right? So it appears that currently, if there are 20 or more employees are employed, then the bonus part will be applicable, right? But the act is silent about what will happen if subsequently the threshold limit falls below, right? Currently, in the payment of bonus act is very clear. Subsequently, if it falls below, the act will continue to apply. But the code is silent, right? And it also, the wordings, if we go through the wordings very keenly, it very clearly says every accounting year, at least for a single day, there must be at least 20 workers. If it is not there, then for that accounting year, the bonus may not be applicable. So it can maybe come to a position that for 2-3 years, an employee will continue to pay. On the 4th year, if the employer does not engage even for a single day up to 20 employees, then he may not pay for the 4th year. It appears like that. But again, I'm not very sure. Is it an error or it is intentional? Then calculation of remuneration, we discussed at length. I think calculation of remuneration is very, very important. Some clarity is, if it is not given, then I think it will be difficult for the employers to arrive at the wages, right? Because the term wage is based on remuneration again. Then the financial commitment, yes, the wage is getting increased, and irrespective of whether the establishment is covered under the ESI or not, now creche is to be provided by the employers if there are 50 or more employees. And of course, for obligation towards contract with the amenities, if you go through section 16 of the current Contract Labor Act, the liability is on the contractor, right? Only if the contractor fails, the liability passes on to the principal employer for providing all the amenities, starting from providing drinking water, right? But now in the code, the liability is directly lashed to the principal employer. Then I think penalty, I think it has gone up like anything, right? So I think again, the point here is emphasize on the compliance and amenities for transgenders and social security for unorganized. I think we discussed on the gig workers, the platform workers, the wage workers, the home-based workers, right? So I think they will not be treated as workers. So take, for example, the Ola driver, right? So whoever is managing the Ola operations, he is not treated as employer. Or the person who is availing, the individual or the organization, they are also not treated as employers. But this person as a driver, he is doing some service. So it falls beyond the traditional employer-employee relationship, right? So he can fall under the definition of platform worker or even under gig worker. It is possible in both the cases, right? But they are to be extended the social security benefits. That is the idea of the government. As we I think some slide showed that there are around 50 crore workers, of which only 10%, that is 5 crore workers, are there in the organized sector. Rest 45 crores, they are in the unorganized sector, and they are not entitled for, and they do not have protection under the set of these labor legislations at all. So the idea is to extend the social security to these persons also. So, but it will not be with some employer, right? So some authority will be fixed, and these people need to produce their Aadhaar card and register themselves with that authority. And if that is done, then I think whatever is due social security, then that will be provided to them. And the separate fund will be created for that. That is the idea. I think we have come to an end. Once again, thank you so much for the opportunity, and thank you all the participants for your patient listening. It's now over to you, Suchita.
Hi, thank you so much, Mr. Vardhan. I think this is definitely not a subject that we can cover so quickly. And by the nature of questions that we see, I think we have a lot to cover for sure. But thank you for the attempt that has been made today by all the respective speakers, Mr. Vardhan from Aprajita, Sushil from GI, Unik Krishnan from Randstad, Mr. Shohas from Personal, Madhu from Quest. I think I cannot thank you enough for taking out this precious time, even though I know this has not been done as per your satisfaction, but we will try to have more detailed session individually after this highlight session today has been done. Moving on to, may I invite Pritesh from Staffing Board to just give us a little bit of an highlight about the product that we have today that we can discuss, and post that we'll start taking the questions from all our participants. We are very thankful for all the questions that have come in, but in the meanwhile, if you want to post more questions, please feel free to go ahead and do that. Welcome, Pritesh. Staffing Go is one of the partners that we have, and I welcome Staffing Go for this session.
Thank you, Sujita, for giving this opportunity to Staffing Go to present the solution. So, ISF and participants, we as Staffing Go are sponsored for this particular event, and in next today's 10 minutes time, I will present you the benefit of the Staffing Go and how you can, as a staffing, if you are in the staffing industry, how you can reduce your overall investment on the software side. And by taking this opportunity, let me start with certain slide, which is basic information related to the staffing companies. Little bit boring, but let me take it further and see through how exactly I am trying to present the overall benefit from the staffing go. So typically staffing company, as we see the day-to-day business operations, there will be a business development activity by the sales team. There will be a sourcing and the interview or the offer by the recruitment team. There will be a client specific onboarding, which will be done by the onboarding team. There will be a HRMS or HRIS system, which is the HR team works, the queries, leave management, etc. are getting clarified. The payroll team who validates the timesheet and does the payroll processing, and there will be finally the accounts team comes and who takes the various inputs and does the accounting or the say financing thing. So there are various departments are associated with the staffing companies. So it's not that one particular department can run the entire staffing operation. So with this, we can say the various companies goes with the various software solution. There are very good softwares are available, but let me focus on the today's challenge and the problems. So for example, for the sales thing, people use from the vendor A some sales management software, some ATS from the vendor B for the recruitment activity, for onboarding some other vendor or some independent the onboarding can be used, or some HRMS system from the another vendor, vendor D, or the say payroll system from the vendor E, and say some accounting bookkeeping software from the vendor F. So there are various softwares required. Some of the things where the vendors are common, some are the vendors are different, some are the activities offline, online team is presenting. Now overall, if you look at there are multiple standalone business applications are there, and various functions, various departments are getting used by this particular application. So what overall is happening? If you have multiple vendors or the multiple software, definitely it is going to increase the budget and the investment for software. All these systems are not interlinked or not interconnected. So definitely there will be a time and investment, and definitely there will be some kind of errors. And we know that all we work into the staffing companies with the margin and the markups, right? And it is very risky to take any kind of errors, and at the month end we will be not able to submit the invoices. So what as a staffing go we are doing is we have merged the entire thing into the one single integrated system. So there will be no multiple applications you require. The single integrated system can, starting from your lead management, your client informations, your contract management. In the contract, there is a detailing the contract system where each PO line items, billing informations are there. Your recruitment ATS are taken care, your consultant managements are taken care, your timesheet inputs are taken care, your payroll and collections are taken care. So this is a single system where end-to-end staffing process automations can be done. Apart from that, there are add-on like your consultant welcome portal, your consultant self-service portal, your customer interface, or any kind of accounting tool you are using and you want to integrate, we can do it. So as we know, the staffing is not just staffing operations where there are various staffings are there. Perm staffing is there, contract staffing is there, some places the managed service staffing will be there. So all the kind of staffing requirements can be fulfilled through this particular staffing go software. So if I want to not sell in the staffing go, so there are certain things like automating your client contract or MSA terms, multiple billing cycle times, markup based reimbursement and mid-month process, billing and the payroll of the consultant staffing or firm staffing, your bench management and redeployment, invoicing, collection tracking, salary arrears, LOP reversals. All that is possible through the single system called staffing. You can digitally manage your all and contract terms. And in contract terms, if I want to go in detail, there are various things are the PO line items, SIPs item, billing methodology, your MSN purchase orders. If I want to take it further, your lead, time sheet, consultant, reimbursement, mid months, all this is possible through this particular system. Now, if I want to take it further in the product demonstration, if I go and instead of showing you the PPTs, let me take you to the system where you can see that there are various modules are available: dashboard, sales, plan, contract. Sorry, I'm not able to show this one. Yeah, there are various modules are available: your sales module, your client module, or consultant module, your requirement module, or sourcing module, onboarding module, and reimbursement module, the time sheet, payroll. As I was talking about, there will be a separate sourcing and invoicing modules are there. So there are various modules are available inside that. With this, if I want to take you to one of the examples, so for example, in the financial, if you go into the finance and you want to see your invoices, and the invoices you want to see the all kind of your employees, whatever the invoice is there, and if you want to see to detail invoice, you will be able to see the detailed invoice also. So like invoicing, if I want to go into the now, let me take you into the payroll. In the payroll also we have like pending clocking, pending invoicing, pending the time sheet we have. Now it's a invoicing pending, and if I want to go invoicing pending, I can go inside and I can look at the various kind of requirements like your pay register, any kind of ESI report, PF report. So overall, this entire system is interlinked. Like your finance is interlinked with your service sourcing, payroll is interlinked with the time sheet is interlinked with your consultants, consultants interlinked with the onboarding is interlinked with your requirement or the client contract. So entire stuff is available in our single system. So I will take you further in this. So these are the various modules are there. Yes, you can see through the modules. So there are customers who is chosen our staffing go, and the companies right now using our system. This entire, as I was telling, that this entire staffing go understands your staffing business, and I am definitely sure that through us you can deliver your brand or value stands for. And let's experience the quality product and quality supports from our side. You can reach it out to us by given the number. Mr. Balaji is my co-founder, co-partner, and there is a website called staffinggo.in. Okay. Thank you, team, for your wonderful participation as well as the cooperation. Thank you, ISF.
Thank you so much, Pritesh. That was really very nice of you to share not only just the presentation, but to take us through the product. It gave a lot of insights and helped us to also understand the possibilities that this product can help the organization do their functions better. I'm sure most of the people who will be interested in knowing further, they will write to you. We will leave the email IDs for everybody's interest and to connect with you further. Now, I think with the time constraint that we have, we will quickly have to jump onto the questions. Thank you so much. I think most of the speakers have addressed the questions that were there, but still the questions that are there, if I may request Abhishek to start reading out the pending questions, and we can request one of the speakers, depending on the nature of the question, if they can start addressing them. Or if the speakers would like to choose the question that they want to address, we'd be happy with that process as well. Madhu and Mr. Vardhan, because Suhas has been kind enough to give us so much of insight, but if you would want to choose the questions, at least on the wages and the HRA, the last questions that have come in, it looks like they have been directed towards you.
Yeah, I think I've already addressed few questions in the box. Still, yeah, if there is any question, I can.
So one of the questions that have come is on the, somebody has requested if we can repeat the slide of 50% wages salary and the slide, which is slide number 10 and 11, that was been requested. So maybe if you want to share the slide or you want to quickly discuss that particular slide again for the benefit, because that was quite an extensive discussion slide that was there.
So you want me to share the slides now?
Or you can discuss it, or just the salary, the 50% salary, what the components are, because I think one of the questions also said that can HRA be broken into the parts? I'm just trying to look at that related question over here. Abhishek, if you could help me out, please, on this.
Or if they can drop a mail, no, I can address.
Sure, we will leave the email IDs for you to take on from there.
But
so
honestly, I'm not sharing the PPTs because I think it is not yet complete without rules, right? So sure. I think it is not advisable to share the PPTs now.
Yeah, and also for the benefit of all the participants, this is very individual organizations' views that we have tried to give the best inputs from. At this point of time, as the rules are still not clear, there could be ongoing changes that will happen, and we will ensure that our upcoming future webinars that we keep doing, we will be keeping on updating on all the developments that will happen.
Maybe just to substantiate that, one specific example, if you go through the definition of the term employee under Code on Social Security, right? Currently, we are all aware that there is a ceiling of 15,000 available for PF. But if you go through that definition of employee under section 226 Code on Social Security, it appears that the ceiling will not be available for provident funds. It will be available for pension scheme. It will be there for EDLI, right? But I think we may have to wait for the scheme to be announced.
Right.
Yeah,
That's true. Okay, I
that
think
is
one
one
question.
classic example.
Absolutely.
Yeah.
The question that I would like to take on here is what would be the major impact on staffing companies with the simplification of the labor laws?
Okay, I will attempt it. See, essentially, I think it is overall, I think the number of compliance points are going to reduce from a perspective of each state under CLRA itself, the different types of registers to be maintained, returns to be filed, and some states wanting your returns to be filed off yearly, some yearly, and all of that. I think probably the returns might still have to be filed, but probably we'll have to wait, as Swarnim rightly said, how the rules are going to be published by the center, and then how the states are going to adopt the central rules, or are they going to come up with their own ones. Subject to that, I see a lot of those points becoming easier, and maintenance of registers, etc., in hard copy, those kind of things will ease, will also. Now it is very clear it can be maintained in soft copy. And the major one is the licensing regime. I think that's going to be, again, we'll have to wait how the rules are going to be formed and what's the process they're going to finally adopt. But it looks like the registration of the principal employer and the licensing of the contractor is kind of separated. And if that is going to happen, I think that will give a lot of relief. And they're talking about a national license. So probably staffing companies spread across more than one state may not need as many registrations as their relationship with the clients, and probably they can at best live with each state they represent, one license in each state. But that I'm just saying it is subject to what the rules are going to come up. So I see from a perspective of the compliances in a procedural manner, it's going to become a lot more easier. And if you have set up your structures and have automated many of the compliances and all of that, I think you will be able to give that comfort to your clients as principal employers that generally you are a compliant organization. That's one. Second, in general, the procedural, decriminalization of the law, right, with regards to most of the imprisonments being taken off. Of course, the penalties are high. So, so it's a trade-off between, for everything you being taken to court, you pleading guilty for a small stuff like display is not maintained, and then you are forced to pleading guilty and go to the court and all of that. Probably the procedure has been simplified, and but then since things have been made simple, the cost of non-compliance is high. So I think that is the trade-off. But I think staffing companies needs to really ensure that they have put systems and processes in place so they are in compliance, and and also ensure that principal employers support them with regards to points of compliances where they are dependent upon principal employers. So this will also give an impetus to the principal employers also to be kind of prompt and responding to contractors' requests. I'm hoping so. And accordingly, they are also within the law, and essentially the pain points on compliance with regards to small requirements which are difficult to keep track of and ensure compliance, I think will come down. So these are the two aspects I think which is mainly it's going to be beneficial. And all of this is subject to how the rules are going to come out, how the states are going to adopt the central rules, and what are the variations the states might bring up, and again recomplicating our lives, complicating possibility of complicating our lives again.
I have the next question, which is basic wages less minimum wages in employee salary structure?
Sorry.
Is basic wages less? I'm assuming the question would be, will the basic wages be less than the minimum wages in employee salary structure?
Possible. Basic DA can be equivalent to minimum wages, no?
The
So
next
it is possible. But the point is, no other component can come in once the code is through. It can be either basic alone, a consolidated salary, or basic plus DA. Particularly when we pay mere minimum rates of wages. Right? Yeah.
Yeah. The next question is, the currently factory deploys trainees for 1 or 2 years period. Will it fall under FTE when the new labor codes are implemented?
No, trainees are different. Trainees are not employees.
Absolutely.
Yeah.
It
If work,
all depends on the contract of employment and how they term it.
Yes.
FTE with clear cut, FTE comes with experience, training comes with no experience. That's simple it is.
See, FTE, when we say FTE, fixed term employees, they are to be treated on par with permanent employees. That is number one. The services of the permanent employee will get terminated, say, on attaining some age, superannuation age. It could be 55 or 58 or 60. Whereas, on the other hand, this services of the fixed term employees, that will be governed by the terms of the contractor. It will be for 3 years or 4 years or 5 years, whatever the contract says. That is the only difference. Otherwise, they are to be treated on par with the permanent employees.
okay. There is another question, which is, as HRA is excluded from the definition of wages in new wage code, will it not affect the employees' income tax exemption too, as no organization will continue with HRA components in CTC?
No, still the companies can continue to pay HRA. They can have HRA as a component in their salary structure, but that will not have any impact on Income Tax Act, right? This implication is only for labor legislations, labor codes.
Or whether trade union will be abolished if worker strength is less than 300. And there is an additional question which is slightly related. If worker strength is less than 300, is it mandatory to have a negotiating council? Slightly different, but
the relationship, the understanding is the recognition to the union, whether they have the 51% or more support or the membership of the employees working in that company. If they have, irrespective of the number, it could be 300, it could be 50 also. Therefore, my presentation says this Act, Industrial Relations Code Act, applies to all establishments. Even the factory having 50 workers also may have union. If they have 26 workers, they can be recognized as a union. So, irrespective of that.
Yeah, I feel, just to add, I think the querist has mixed up between Industrial Disputes Act and Trade Unions Act. The threshold number of 300 is applicable for the application of Chapter 5B. That is for the industrial establishments to take permission in case of retrenchment or layoff. That is different from trade unions provisions, right? I think let us not mix up both. Both are different.
so have we also addressed, if worker strength is less than 300, is it mandatory to have negotiating council?
Yeah. Again, negotiating council comes into picture only when there is no single union which is giving the majority of representation. If there are more than 2 unions and if they still have less than 50% majority, 50% support or the membership, it is the employer who has to decide. No, he can. He did not recognize any one of them. He chooses one person from 20% of that block as a representative and form a board of 5 people and form that negotiating council. Okay.
See, just to add, as Mr. Suhas said, no, just forget about the number, irrespective of the number of workers an industrial establishment has. If there is a sole trade union, that is to be recognized. That is number one. If there are multiple trade unions, then the one union which has the support of more than 50% of the workers, that is to be recognized. So that will become a recognized trade union. But if none of the trade unions has the support of more than 50% of the workers, then the negotiating council is to be formed by the employer at the ratio of 1 representative for 20% of workers. So that is how it is.
So the employer has to take the initiative of forming the negotiating council in the interest of workers to create and maintain their industrial peace and create a forum to address their working related issues.
Yeah.
Understood. Next is on the ESIC. So now for ESIC, the salary components considered are only basic and DA. If it is less than 21,000, then employee is entitled for ESIC contribution. Does this continue?
No. Currently, I think we are considering the gross salary. Currently, as per 222 of current ESA Act, right? Again, for the purpose of code, again, please go through the definition of the term wages. Whatever is excluded, excluding that, then you arrive at the figure. If it is more than 21,000, then that person is out of purview. If it is less than 21,000, then he is to be covered under ESI. Yeah.
Okay. If a company has more than 20 employees and employees do not want to get enrolled under PF, so how should this be handled in the new code of Social Security?
There is no option for employees.
There is no.
If it is otherwise to be covered, registered under the Act, yes, it is to be done. There is no option. See, the option is, particularly in the case of ESI, the threshold limit now is, as per the code, it is 10. If there are less than 10 employees, say for example, 8 employees, of the 8 employees, if 5 are agreeing for voluntary coverage of the establishment under ESI, and if the management is also agreeing, then they can go for voluntary coverage. That is what is mentioned there. It is not for individual coverage. It is for the establishment coverage, like what we have for PF currently, as per the 1952 Act. So voluntary coverage is possible. Similar, as of now, I think under ESA Act, voluntary coverage is not possible. That is now brought in through the courts.
Add one more perspective in this. If this query is raised by an employer, then it is very imperative for him to understand the preamble of the Act, the objective, to provide social security to people employed therein. So he has to make them understand the importance and the benefits of PF, EPS, and the various insurance schemes under the Act. And that to convince them how important it is for them for their provident fund accumulation, pension, and all those kind of things. But if the query is raised by an employee who wish to not to be part of this PF coverage, I think then it is a different ballgame altogether. He needs to understand how he can create the purpose by way of contributing and getting the equal percentage of contribution from the employer. If he puts a little effort to study the EPF Act, I think it is beneficial to him too, very well. So it's a message to both the parts. Either of them is there. Raise this question.
Thank you. Can bonus be paid monthly as per new code? Will there be any provision for the same?
If somebody knows answer for this question, no, that person will become a judge in Supreme Court now.
Absolutely.
Okay, so what the current even the current Payment of Bonus Act, it contemplates payment of bonus only once, that is after the end of the accounting year. That is number one. Number two, as per current section 17, it allows some customary payment to be made, which can be adjusted at the time of declaring the final year end bonus. These are all the two things which are clearly there even in the provisions of current Payment of Bonus Act. I think the same thing continues here also, right? For some reasons, for maybe administrative convenience or some other reasons, employers have started making payment on regular basis, monthly basis. Actually, when we say it should be based on the surplus available, right? I think that can be arrived at only after the finalization of accounts is done. Right. Of course, customary bonus, puja bonus, festival bonus, that is permitted as per section 17. That can be adjusted. I think since many of the companies are paying on monthly basis, I think every month they are paying it as bonus advance. 20% monthly, reckoned monthly. And finally, when they declare final year and bonus, that is getting nullified with this, adjusted, 100% adjusted. So they are making it zero in the accounts. Yeah, better, even if that is done, procedure-wise, that is safer. Please do not show that in the wage register or any of the official records. Otherwise, you are caught.
Okay. Moving on to the next question. There are judgments to effect that guaranteed allowances are covered by the substantive part of the definition of wages. Will this position hold even now?
Yeah. I think some of the states, HRA is mandatory. Maharashtra, West Bengal.
West Bengal, yes.
Right. So they have to pay necessarily. Yeah.
One of the companies have, I think, posted, we have considered basic plus VDA plus HRA as minimum wage. Is it a right practice?
No.
I think currently, yes, for the purpose of Minimum Wages Act alone, but it is not right as for the for the purpose of payment of bonus, because for the payment of bonus, the working should be done at least on the minimum rates of wages as per the judgment given by Delhi High Court, right? I think in 2011. Subsequently, only based on that judgment, I think this cap of calculation of 7,000 or minimum rates of wages, whichever is higher, that was brought in section 12, right? So this is okay for the purpose of if you are bringing in HRA and your total gross is total comes to only minimum rates of wages, that is okay for the purpose of Minimum Wages Act, but that is not okay for the purpose of Bonus Act.
Bonus Act.
Right. So if at all, if we want to be compliant under all the legislations, I would say basic and DA should alone be equivalent to or more than the minimum rates of wages. Whatever allowances we want to pay, that should be over and above that. Only then we can say that we are compliant under all the legislation. Otherwise, there could be a compromise. Somewhere we may get caught.
Are the IT industry exempted from the Trade Union Act?
I don't think so.
Sorry?
So
The IT industry is exempted from Trade Union Act. No industry has any such specific.
That is, law is silent on that part. So one cannot comment.
If the
All establishment, it says it applies to all establishments having 30, where 300 and below. So for standing orders, 300. For other provisions, all establishments, irrespective. So law is silent on IT part at this moment of time.
Yes, Mr. Vertan, you wanted to add something.
See, exemption under Standing Orders Act is available in Karnataka for IT industries.
Only
in Karnataka alone. So we may have to check in other states. But for trade union again, it is formation. It is an association. So if somebody is prevented from forming an association, then that goes against the fundamental rights.
Against the constitution. Yeah.
Right. So I think that is not permitted as far as I'm concerned. But for standing orders, in Karnataka, the IT industries are exempted. I'm not very sure about other states. We may have to check.
Sure. If the industry has 50 male employees, do we need to maintain? I'm sure the person wanted to ask company. If the company has 50 male employees, do we need to maintain creche?
Yes.
50 or more workers, yes.
They say 50 or more employees. They don't say women employees.
Does Occupational Safety Code applicable to the industry registered under Shops Act?
More importantly, yes. Yeah, please go ahead.
No, if it is 10 or more, yes, OSH code is applicable. The SND is still valid. We don't have any change in the shops and establishment. OSH code will still be applicable if it is more than 10 or more employees are there.
SND, so Shops and Establishment Act is here to stay. So it continues to apply to that establishment.
That will basically state law actually.
State law.
Yes,
Yeah.
Mr. Vedant.
Code on Social Security. So PF, ESI, gratuity, employment exchanges, maybe all these legislations will automatically apply, even for establishments covered under shops and establishments. That is again state specific. Similarly, IR code will also apply. But when it comes to the question of occupational safety, see, when I say occupational safety, it contains the set of governing legislations. If it is a factory, then Factories Act is currently the governing legislation. If it is a mine, then Mines Act is the governing legislation. So, but these are all establishment specific. For example, you take current Contract Labor Act. That is also a governing legislation, but not a governing legislation for an establishment, but for a particular class of workers called contract workers. So similarly, the Shops and Establishments Act is also a governing legislation, but state specific. Right. So I'm not very sure whether the provisions of Occupational Safety Act code would automatically be applicable to establishments covered under shops and establishment. I think there should be some guideline. That would be my opinion. Other codes, fine, because those are all allied legislations, PF. Even today, for the commercial establishments covered under the Karnataka Shops and Commercial Establishments, PF Act will be applicable, ESA Act will be applicable. So that will continue. But I'm not very sure about occupational safety. I think if some clarity is given, that should be helpful for the employers. And more importantly, whatever changes we are talking about, it is happening only in the central sphere. So I think people are saying that there are 44 legislations. I don't know who invented that number. I made a little search, right? I think it comes to around 48 or 49, of which 12 to 13 legislations are already repealed.
Yeah.
So currently, the existing operational legislations are only 36. Of the 36, only 29 legislations are now getting subsumed into 4 codes, right? 3 IR and 4 code on wages, 13 occupational safety, 9 code on social security. So 13 plus 9 plus 3 plus 4, it gives you 29. Still remaining 7 legislations are there, including our POSH Act, Prevention of Sexual Harassment. It is not getting included in the 4 codes which is proposed now. Right. So along with these 4 codes, the other 7 legislations will also have simultaneous application. That is what I feel.
Absolutely.
Are there any plans to club departments like PF, ESIC, labor, and I assume the PTA and all that? Any other departments? Or is there any plan of doing any consolidation?
No, I don't think so. There was a plan even to merge PF organization and ESI corporation. I think some draft was issued known as Small Factories Act. There, I think it had some existing 14 to 15 legislations into it, including ESI and PF. And there was a provision there to give option to the employees to get covered under ESI or to get covered under PF. So instead of ESI, they can choose some maybe other schemes prescribed by IRDA. So that was there, but that got shelved, right? Currently, I don't think any talks like that happening. ESI continues, PF continues, Central Labor Department continues, State Labor Departments continue, and I think this Director General of Mines and all still it continue. As such, the authorities still continue, departments.
What would be the relevance of all other tax-free components after new wage definition? Will it not have a loss of employee on tax exemption part if removed from definition of wages?
I think some tax expert has to see on that.
No, I'll take it. So basically, I think people are getting confused with what is wages from a labor law perspective and what is income from a salary income perspective.
Exactly.
Tax Act. So both are different. And nothing is going to change. So even earlier question, like Vardhan rightly answered, HRA can remain, and HRA you will get the same benefits in the Income Tax Act. Whether that HRA will form part of a basic as a minimum wages or form part of basic for or wages for PF is a question that needs to be addressed based on Social Security code or whatever is the relevant code. So I think they both have no connects. Only thing you need to be careful is if you structure your wage components with IT in mind, don't lose out on inclusion or exclusion appropriately for wages for the purpose of PF, ESIC and all that. You need to structure your PF wages accordingly and include wherever it is required, exclude wherever it is required. So you need to treat them both separately.
Sure. The connected one is if HRA is guaranteed under the terms of employment and thus falls under the substantive part of the definition of wages, should we consider it as wages?
No, it will be over and above basic and DA. It can operate only in that fashion.
What will be the impact of per day 8 working hours on IT industry working 5 days? Is this question elaborated enough to address?
No, there's nothing like that. The working hours, the provision is very clear. And if 5 days of working is an option or a discretionary part on the part of employer, so there is no correlation. Well, see, employer can employ people for less number of hours. It's up to him.
Yeah, I think today also And the provision is there, and then everybody is working without any major issues. So I don't know why there is confusion at all.
There is another question for ESIC registration. Headcount of employees is 10 and gross wages of all employees is more than 21K. Do we need to take a registration?
We have to count all the employees, irrespective of the salary is less than 21,000 or more than 21,000.
There are conflicting interpretations like coverable employees and non-coverable employees. So the employer can refer to those case laws, the interpretations, and take a call. Because non-coverable employees need not be registered in the ESI because it becomes a compliance-related hassle from that perspective.
But their headcount is to be included for coverage of the establishment. I think Madhu can explain on that, no?
In today's scenario, in isolation, they need not, but in the near future, automatically they will be covered under ESI. As and when the employees fall under the definition of or the eligibility criteria of ESI, they will have to be, the ESI facilities or the coverage will have to be extended. That's what that's going to be the scenario going forward.
Moving on to the next question. Does gig worker includes home workers and piece rate workers typically associated with the garment industry? If not, under what category are these workers covered?
They are not covered at this moment, I guess. The law is very silent on their inclusion.
Okay. But there is a discussion on the gig workers going on with the social security. Is there anything that we can add from those points?
See, piece workers are different. Already they are there. And they are not considered as unorganized workers. Right. But now what we are talking about in the codes is gig workers, platform workers, home-based workers, wage workers, and self-employed workers. Even out of these 5, home-based workers are already there. Take, for example, typically the cigar and BD and cigar industry. It is prevalent. Match industry, it is prevalent. People will not come to the industrial premises. They will just take the work to their homes. They will work from there. They are not employees of the establishment or the industrial premises, the industrial establishment. But they are still entitled for social security. Maybe for PF alone, for PF ESA alone, they are treated as employees. There are judgments. Right now, all these 5 categories who are, I think, who are in the unorganized sector or who are directly unorganized workers. Now the social security benefits are to be extended to these people also. Right. Again, that is the reason I gave the example of Ola driver. Right. He may get some commission for that particular drive. Otherwise, no social security protection he has. So if he has maybe other proper records, including the Aadhaar card, he may have to register himself with an authority who will be prescribed. Right. Then he can get the benefits like the other benefits we get, say PDS, public distribution system, right? Maybe using Aadhaar. So for getting any benefit, now I think Aadhaar is a mandate. If you are a citizen of India, Aadhaar is required for getting any benefit. That is the reason I think they are linking everything, now, be it industrial workers or maybe they are mere citizen of the country. But Aadhaar is required. Without Aadhaar, I think nobody can get the benefits maybe going forward, right? So it will be extended to them in that fashion. Nobody will be specifically designated as their employers. It is not possible. They will still continue to be in that sector because 45 crore workers are there still in unorganized sector only. Right. But they will be given extended certain benefits by some means. That is the idea. Like the public provident fund for the professionals, because the provident fund is available only for the industrial workers.
Right.
I think that actually mooted out the other idea of public provident fund, which is more for the professionals, in fact. But now it is optional. Anybody can, even industrial workers can go and contribute towards PPF. That is there. I think it is with post office or it is with bank. Right. So that is how it is.
Sushil, you wanted to add something?
No,
You're on
that's
mute.
it. No, that's it.
Okay, I think keeping the time constraint in mind, we'll take only the last question that we have. It's under IR code, how subsistence allowance will be calculated?
I think it's pretty straightforward. I think they have given for the, if you suspend a person and for the first, correct me if I'm wrong, others can correct me. I think for the first 90 days, it's going to be 50%, and after that also, if it is extending, then it has to be 75%, which used to be part of standing orders of individual factories and all of that. And in Tamil Nadu, I think there is separate legislation which wanted the subsistence allowance to be paid. Now they have brought it under the code itself. So if you are going to suspend a person and you can't just stop paying wages, and unless otherwise the inquiry is not completed for the reason, because of the reason that the employee is not cooperating, you have to pay the 50% or 70%, and after a particular point in time, it becomes 100% even. So you need to do that. This kind of ensures that employers will conduct inquiries promptly and ensure that complete the process and take action appropriately instead of just keeping somebody suspended inordinately. And also you need to take into account that this is payable only if the suspended employee is not working in any other place and earning wages. If he's doing that, then that also need not be paid.
I think,
Yes, Madhu, I think it is a straight provision in the IR code.
Yeah.
And even if beyond 180 days, still the inquiry is not completed, then 100% wages.
Thank you so much. I think we've come to the end with the last few minutes for me to just wrap up this session. We had a great session. Thank you all speakers, Mr. Vardhan, thank you from Prajita, Suhas, MD from Personal, Madhu, Head of Compliance at the Group, Head Compliance of Westcorp, Sushil Sir, Head of Compliance from GI, Unni Krishnan, Head of Compliance as well as Company Secretary Randstad India. Thank you so much, Pritesh from Staffing Board. Thank you, Lohit, for making time for the session. I think we have had a brilliant start. Obviously, as we progress, we will be making discussions related to each code. And thank you all the participants who have stayed with us. So we started with 400 plus today, and it's an exciting session we've had, considering that we could barely touch upon most of the points. I would request all the speakers to give us more time for us. I mean, I understand this was an ISF session which was planned in a short way. We will ensure that we reach out to the speakers and request them to give individual time slots to have individual discussions with all the participants joining back again. Thank you all of you. Thank you so much for your time. Thank you attendees and thank you.
Thank you. Thanks
Thank
for
you,
the.
everyone.
Thank you all.
Thank you.
Bye-bye.
Thank you. Bye.